everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's coverage, we come finally once, and hopefully for all, to the end of the Karen Read trial. I say hopefully because, of course, there's always the chance of mistrial, and we could do this all over again. That's an exciting future for us all. Before the moment, let's discuss where we are after the end of I don't even know how many eternities of trial we've been through. The closing arguments are finally coming to an end. The state put on 8 weeks of testimony and the defense put on like 2 days because, well, they didn't need to say very many things because they actually had experts who knew things. And, there wasn't a lot that they needed to say, so it was kind of quick. So that was fun and exciting. Cool. So anyways, the closing arguments are this morning, and then we'll have the final selection of the jury, and then the jury will deliberate, and depending on what the jury does, perhaps we'll have an answer sooner rather than later. I'm voting for 10 minutes. It's probably unrealistic, but one could hope. So yeah, Karen Read, of course, is accused of second-degree murder, vehicular homicide via DUI, and something else, I forget. But yes, she's being charged with murder a couple different ways. So yeah, that's what's going on. And there's many, 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 many reasonable doubts. All the reasonable doubts, so many reasonable doubts. It's hard to contemplate how many reasonable doubts there are. It's like, where do you even begin trying to accumulate the reasonable doubts? Is it the shoddy investigation? Is it Proctor with his seeming interference or attempted interference or desire to interfere with various parts of the investigation, including interfering with the independent judgment of the medical examiner? Is it the missing 42 minutes of video at the Sally Port? Is it the ghostly presences on the Sally Port video? Is it the inverted video on the Sally Port video? Is it the fact that the Canton police, despite being recused, were somewhat directly involved, including the chief of police himself, including the Alberts, who, of course, are the homeowners, and they are directly involved in the investigation despite the recusal? Is it that? Is it the physics or lack thereof? So one witness we have is the crime scene. We have the crime scene who has spoken apparently via proxy. And then we have, other actual evidence, including this new thing I just heard of called physics, and this other new thing I just heard of called mathematics. And apparently, according to this new thing called physics and this new thing mathematics, this doesn't make a lot of sense. So I guess it depends who the jury believes. Do they believe the crime scene? Or do they believe this new exciting thing called physics? So, we'll see. So the jury is supposed to get the case today after an hour after an hour of closing each. Normally, I think an hour is pretty long, but to summarize a trial this long, but I'm sure the defense can do it. I'm sure they can summarize the thing in an hour, but it is a lot to cram into an hour. I will concede, because it's like, where do we even start with counting reasonable doubts? That'd probably be my strategy if I were going to put together a closing argument. I'd just literally start counting them. That'd be my first thought anyway. But yeah, we'll see. Of course, there is always a base chance the jury convicts just because there's a defendant sitting at the defense table. And I've estimated that chance at 5%, which sounds roughly correct. I really hope that will not be the situation here. But you never know. One juror gets a bug up their ass and refuses to play nice, and the other jurors do some sort of compromise verdict or something. So we'll see. We'll see. And that is where we are today. Yes, the red solo cups, the unlabeled, unmarked, unsanitary, uncovered red solo cups in the unsanitary brown Stop and Shop bag taken to the lab that one of the cups were tested and then weren't even really tested. So, yeah, the unknown DNA on the clothing of Mr. O'Keefe that has never been tied down to anybody. The medical examiner even's like, yeah, this doesn't really look like any sort of vehicular accident I've ever seen. Massachusetts police make sled look fantastic. You may be right. You may be right. What are the odds she's found not guilty in his death but still gets the DUI? I don't know. I mean, I suppose that's not one of their major concerns, but do I have a cold? No, just my allergies kicking my ass. Excuse me 1 second. Okay, we're back. All right. Just put in a little saline, and hopefully that will help with the issues so you don't have to deal with me sounding weird. Isn't she she's charged with DUI? Isn't it a bit late? No, it was a part of the original charges. Yeah, the DUI is in conjunction with another charge. Yeah, let me see if I can find the official list of the charges. Because I'm pretty sure it's second degree murder, a DUI, manslaughter, and yeah. So there you go. Yeah. So it is second degree murder, motor vehicle manslaughter while driving under the influence, and leaving the scene of a collision causing injury and death. So that's what the three charges are: second degree murder, DUI, manslaughter, and leaving the scene. Those are the three charges. So there's no naked DUI charge. It's DUI, it's manslaughter via DUI is the charge. So they still have to find that she still hit him with the car, leading to the death. But as opposed to second degree murder, where it's intentional, that would be just an unintentional killing. Vehicular manslaughter with DUI and leaving the scene. So yeah. What witnesses did the defense call? The defense called the snowplow driver, Lucky, who is our hero. They called a retired medical examiner with all the experience, including many papers on the subject of dog bites. They called two reconstruction experts from an independent agency, or that were hired by an independent agency, and the FBI. And they talked. So those were the experts they called. Can any lesser charge be appealed? Yes, but there are no lesser charges. There are no lesser includeds. The government went through that. So there are no lesser includeds. Neither the prosecution nor defense asked for lesser includeds. So it is the naked charges. It is second degree murder, period, DUI, manslaughter, period, and leaving the scene, period. There are no lesser includeds with any of those. So it's all or nothing within its domain. So I'm not sure why they did it that way, but that's what they did. Thank you, Alan Parker, for the gift memberships as always. They are extremely encouraged. There should be a unanimous decision before lunch. I'll tell you what. That'd be nice. The defense witnesses were competent. They knew what they were talking about. They used formulas. I don't remember any of them using the word stuff at any point. They left involuntary manslaughter in? Yes, as a charge unto itself. They don't have lesser included within the charges. So they have the second degree murder, they have the DUI manslaughter, and leaving the scene. Those are the three charges. They don't have lesser included within those charges. So they don't have, as an alternative to second degree murder, manslaughter, because that would be a lesser included. DUI manslaughter is a separate charge, not strictly speaking a lesser included. Or it's been charged separately at least, right? So every, it's an issue of like stacking. So this is like that murder comes in like 8 different flavors, right? Depending on your jurisdiction, murder comes in like 8 different flavors, right? First degree murder, second degree murder, third degree murder, voluntary manslaughter, involuntary manslaughter, vehicular manslaughter, negligent homicide, right? So murder might come in like 8 different flavors, and they usually stack one on top of each other, right? And so every level is adding something more. That's what changes the levels, right? So you just add more things, but they all sort of are part of the same stack. So charging the top thing implicitly includes everything in the stack. But they didn't choose to charge any, they didn't choose to provide the lesser included. So they're just providing the one thing. So it's all or nothing within the stack. It doesn't include, just straight manslaughter, for example, as a lesser included. So that's what I mean. And hopefully that's clearer. What is this even about? What this is about is the murder or the death, I suppose, of John O'Keefe, because whether or not, well, I suppose he was murdered is probably a pretty reasonable conclusion, but even then, I suppose you could doubt. This is about the death of John O'Keefe. John O'Keefe is the argument from the state is that Karen Reed was dating John O'Keefe and that she killed him, and they were having some sort of relationship discord. They weren't getting along very well, and she killed him, potentially out of rage / jealousy / whatever. So that's what the case is about, is the death of John O'Keefe. And the defense has done a pretty reasonable job. Well, to be quite fair, the prosecution's done a pretty reasonable job of poking holes in their own case. I was about to say the defense did a pretty reasonable job of poking holes in the state's case, but I think the state did that pretty well by themselves, to be quite honest. So, John O'Keefe died at the home of the Alberts at 34 Fairview, and he was found in the snow, housed long to die in cold, and died as a combination of some sort of injuries / hypothermia. Karen Reed has been accused of the murder and all the rest of it. I think Karen Reed ought to be charged with libel as well as slander, although it probably has to be a civil lawsuit. I don't know what you mean. I'm not sure who she would be libeling or slandering. So I don't know who that would be, what that would be. And within the confines of the case itself, there is litigation privilege. You can't sue somebody for statements they say within the context of the case. And also, Karen Reed hasn't said anything. So I'm not sure how you would charge her with libel or slander because she didn't say anything. So that doesn't really work. And you can't sue the attorneys because litigation privileges, but whatever. Bandit gives $10 to say, what a sham of prosecution this has been. Your coverage has been great and entertaining. Thanks. Yeah. So I'm going to go ahead and amend the video description to add in a description of the case that I've been using for other things. So I'm just going to go ahead and do that really quick so that you guys will know what the case is about in case you don't already know. So let me just go ahead and amend that in real fast. Okay, there. Add in a description of the case. So now it's in the description. So if someone asks, you can just read it. Can I go through all the main characters and what charges they possibly see in an ideal world? I can try. I mean, this is the home of Brian Albert, police officer, and his relatives, also police officers. Mr. O'Keefe shows up to the shows up to the house, but according to the witnesses, doesn't go into the house, if you believe that. He just makes it to the yard, but he has a cocktail glass in his hand somehow, which he apparently got, I don't know, from the waterfall maybe, if you believe that. But O'Keefe is on the property of the Alberts. He is found in the snow and taken to the hospital where he is pronounced dead. The person on trial is Karen Reed, the girlfriend, paramour, who, according to the state, was having problems in her relationship, who might have been jealous because she believed that O'Keefe was having an affair, including when they went on a trip together, that he had an affair when they went on vacation together. And she was angry, mad at that, or just disappointed in the relationship in general, or whatever. There are a lot of the party guests. None of them were properly really interviewed by any of the police. The police never searched the home. Strictly speaking, they probably didn't have probable cause to search the home, but that wouldn't have stopped most police officers anyway. But they didn't, and they didn't even ask for consent to search the home. They didn't even try. They didn't interview a lot of the witnesses in the immediacy of the trial, or the immediacy of the event, I should say. For example, the snowplow driver wasn't interviewed for a full year after the event. They didn't even know he existed. So if not Karen Reed, then who, I suppose, is a reasonable question. But first of all, within the confines of this case, we don't have to answer that question, because this is not a we need to figure out who the guy is exercise, right? Just to remind everyone, because I think it's important, the obligation here is not to figure out who did it. That is not the job. The job is to figure out whether the state proved it beyond a reasonable doubt, which they decidedly did not. I have many, many doubts based on reason. Incredibly many doubts based on reason. And that is all I need. And I can stop. So within the confines of the case, if you ask me who did it, I'm like, I don't know. And I don't have to know, because that's not my job. In fact, you could even think that Karen Reed did it, but not be confident enough, because that's, of course, a possibility. You could think it's more likely than not that Karen Reed did it, if you were so inclined. I don't think that's true, but you could think it's true. I think you'd be dumb to think it's true, but you could think it's true somehow, some way. You could think it's more likely than not than Karen Reed did it. But more likely than not ain't good enough, Chief. So you could simultaneously think Karen Reed did it, and also simultaneously think that the state did not prove it beyond a reasonable doubt. That is a possible universe, if you were so inclined. But, I just know there's reasonable doubts, and I don't really need to know anything else. So if you ask me who did it, I'm like, I don't know. Is there some evidence that points to Karen Reed? Sure. Because if we're trying to think about this from a probable cause standpoint, right, is there enough to bring a charge or an arrest? Sure. Why not? You don't need very much for that. You just need like 1 out of 10 confidence. To convict, you need like 9.5 level of confidence. So you have to get from 1 to 9.5. Is there a 1 level of confidence? Sure. Why not? Is there a 9.5 level of confidence? Not a chance in hell. So I don't know who did it, and to some degree, I don't care. But I think what probably happened is there was, some sort of confrontation in which someone hit him and he fell down, and the person walked away not really thinking about it, probably because they were drunk, and he just died of hypothermia and exposure. That is my best guess. There was a physical fight. He was hit. Someone punched him in the face. And he fell down, and they're like, like pussy, and walked away drunk as he died from hypothermia. That is my best guess. Who that person is? Not sure. We do have some suspects. Could be the ATF guy. Could be the son of the Alberts. It could be someone else. Not sure. And we'll never know. To be honest, we will never know who did it. The dog didn't kill him. I think that's pretty clear. Yeah, the dog didn't kill him. The dog injuries the dog didn't kill him. The dog was scratching away, and there might have been some fight with the dog at some point, or resistance since he was dying in the snow, but the dog doesn't seem to have killed him. But the dog is definitely involved in some point of this, but probably enough to kill, not enough to kill him. So as he was struggling, in the snow and whatever, the dog might have come over him, snatched away his last bit of energy. I think that's possible, but the dog is not the primary culprit here. Does one become a public person due to a publicly aired trial? No, it doesn't become a public person, but it does become a matter of public concern, which is slightly different, but doesn't lead to much of a practical difference. There's hiss in the audio. Check 1 2, check 1 2. Is it better? Okay. Clear audio? All right, cool. Let me know if there's an audio problem. Yeah, no issue. Yeah, let me know if there was an issue. Yeah. Incidentally, and I'm not quite sure why this is true. I'm not quite sure why this is true technically, but I think the hiss issue yesterday was coming from a extender for my for my earphones, or my in-ear monitors. The cable for the in-ear monitors is a little bit shorter than I ideally like, and so I put in a extender, right? Just a female to male 3.5 millimeter cable, right, to make it a little bit longer. And that, I think somehow that extender was leading to the problem with the audio, because I've had that problem before with a different extender for some reason, where it was causing some sort of problem in the mic, which doesn't really make sense, by the way. There's really no reason that the extender for the headphones should cause a problem with the audio for the mic, but I've had that problem before with a different extender. And I recently bought this extender to make it, and it was completely brand new, and you guys were having the problem. And so I think it was due to that thing. And I'm not sure why that's a thing, but that's apparently is a thing. So if you guys have a problem, please let me know if there's further audio issues. And if there's a further audio issues, then I'll probably have to just buy a new interface. But of course I'll do it because, it's my job. I'm not sure why the interface would be a problem, but maybe somehow, some way the interface got shorted out some way. I don't know. Who knows? We'll see. But let me know if there's issues. So that's what I think happened technically, but I'm not sure why. Your hand brushes up against the orange part. Yeah, you might hear my you might hear my hand brush against it or something, but if I touch it, but yeah, fair enough. So if I touch the mic and it leads to that, let me know. I won't touch the mic. I'll just touch the bottom part of the mic. So fair enough. Yes, the police still have Alexis. Yes, they do. I think people just F with you about audio issues because it annoys you. Well, I want to make sure the audio is good. I mean, I want to be a professional as much as one can. Obviously, I want to give you guys the best experience. And so if someone says there's a problem, then I want to make sure to respond to it and try to figure out what the problem is, so it'll be better. Do I think Karen Reed is innocent? Yes. I don't really feel like there's enough evidence to believe it's even more likely than not she did it. So I don't think that she should even be found liable for this. I don't think there's enough evidence, no. When will we know the outcome of the FBI investigation? Potentially never, to be honest. Potentially never. The federal government's domain here is fairly narrow, and so there may never be any release from the FBI or the DOJ, more properly, because the FBI doesn't really do releases ever. The DOJ brings charges. The FBI doesn't really do releases. So yeah. except that one time in which Comey did a release relating to the potential prosecution of Hillary Clinton, which was definitely the exception, and drove a lot of people nuts as a result. So the FBI doesn't really do press releases. So if there's anything that will happen, it'll be because the DOJ brings a charge. So we'll see. I'm not saying your name out loud. I'm not that dumb. And yes, obviously, I live in Texas, hence the flag. Yes, I live in Texas. I live in Houston at the moment. So it is a nice place to be. I recommend it. Leslie, glad to have you here. We'll say hi to some other people in chat. Leslie's here. Para Strokla, I guess. Allison, Just Gold, Kay, AL, Sammy, Crispy Batman. That's a nice name. Deidre, glad to have you here. Don, Laisha, Janet, the Prez, Hobbs, glad to have you here. It's a good day for Uncivil. Every day's a good day for Uncivil. And by the way, now's a good time as any to thank so many of you for becoming members of the channel recently. As you can see, we now have 140,000 subscribers. That's cool. We picked up about a net of about 8,000 subscribers. It would have been 9, but I made a mistake and I lost 1,000 subscribers because Uncivil did a dumb. And I accidentally flooded everyone's feed with stupid. So, even the best of us can make mistakes because, well, I mean, it wasn't exactly my expertise. So, whatever. But, I pulled a dumb, but it's okay. We picked up about a net of 8,000 subs over the Karen Reed trial, and that's awesome. And thank you so much for all of your support over this. It's been helpful. And thank you for so many of your memberships. And we have a nice merch store, by the way. And now, while we're waiting, we can go through the merch store because, hey, whatever, why not? So let's talk about some merch. I need a link to my own merch store, so the bot will tell me. Where is the trial, by the way? Is it going on or what's going on? Am I missing things? I'm probably missing things. No, just the fan. Okay, it was still OnlyFans. I haven't missed anything yet. Ooh, okay, good. I'm not a complete dumb. Let me go ahead and get that set up before I. Well, yeah. Just gonna get that set up so I don't miss anything. All right. Okay. While we're waiting. Oops, what did I do? All right. Go ahead and pin this comment. And I'm going to just open up a new tab. Cool. And do this. Cool. Nope. Nope. Come on. Come on. There we go. All right. Now let's just make it look nice in the window. What mistake? Yeah, I accidentally, the mistake was I accidentally unlisted every single video on my channel. All of them. And then I had to relist them all as public, and YouTube for some reason decided that they were all new videos, all like 3,000 on my channel, and sent out notifications and flooded everyone's feed. That was the mistake. I accidentally flooded everyone's feed with massive amounts of notifications, and everyone's subscription feed was just all Uncivil. And so people got annoyed because they were getting flooded. So that was the dumb I did. It was a stupid mistake, but that's okay. All right, let's talk about the Uncivil Law merch store. the link to which is pinned in the pinned comment above. We have some cool merch I'd love for you to check out. First of all, Callie the Bee Fish welcomes you to the merch store, and Callie the Bee Fish loves you. Okay, so we got some cool stuff. We got this wonderful, cool Being Uncivilian shirt in black. This is nice. Just Uncivil Law, Being Uncivilian, kind of subtle. Nice. That's a nice looking look, right? That's looking cool. All right, my personal favorite item, this actually might be my favorite item, is the Uncivil Law slogan mouse pad. I like this. Learning from the misfortunes of other mouse pads. It comes in two sizes, 18 by 16 and the larger 36 by 18, which I have gotten. It hasn't arrived yet, but it's coming my way, and I'm excited about that. And also the logo mouse pad if you just prefer the simple logo. We also have the Canton PD Forensics Tool shirt collection shirt. So we have the Canton PD Forensics Tool featuring leaf blower, garden rake, shovel, and push broom on a t-shirt. That's very cool. That comes, of course, in a wide array of colors, as you can see. So you can have your choice of colors for that shirt. We have the Evidence Collection sticker, the red Solo Cup Evidence Collection sticker, which comes in a variety of sizes. That's very cool. We have the Uncivil Law tote bag. This is nice. We got the cowboy hat Uncivil Law logo on one side, and then just the standard logo on the other side. So you get both. So that's what that looks like. And that's very, very cool. And my second favorite item, and the one that's been the most popular on the shop so far, is the Evidence Solo Cup. It is a glass cup for your evidence collection needs. The red Evidence Collection Cup. As you can see here, it is property of Canton PD, but that's okay. You can have your very own Evidence Collection Cup, and I hope you will enjoy it for all of your needs. That is a pretty cool item there. We have, just some purple items, learning from the misfortunes of others. Purple mug, just a standard logo mug, shirt. We have the Taint Team data scrubber. So if you want to be part of the Taint Team, you can, and get this mug. Callie the Bee Fish welcomes you to the Taint Team. We got the Uncivil Law, sort of cowboy logo, travel mug. That's neat. Pint glass. Then we got this shirt with the Uncivil Law logo. I like this one, personally. Yeah, so that's good. Is that a typo? No, that's correct. All right, good. And also the tumbler, which is very, very cool. So you can get all that stuff for your needs.
You are unmuted.
So I hope you will check out the shop and you'll consider buying one of our merch items because they're cool. Also, very limited edition, the CSI badge. This badge will very soon be delisted. So if you want your official CSI badge holographic sticker, you can. It features the Canton CSI with their official logo of the brown paper bag and solo cup. And if you would like one of those, you can get that. That's a limited edition item and will soon be delisted from the store. But I hope you like those items. They are available, and I hope you enjoy all that stuff. All right, let's go ahead and get the court feed up. All right. Which one's my favorite? My personal favorite is the mouse pad. My personal favorite is the mouse pad because it's just something I can look at every day because I'm at my computer every day. So, every day when I'm using my computer and, with my mouse, it'll just be there and it'll make me happy because I literally will use it every single day. So the mouse pad will be my personal favorite. And the solo cup is my second favorite because it's just hilarious. But that's my personal preferences. There's a little beep in my ear, which is annoying me. All right, I'm turning down the volume again because the beep is killing me. Yeah, so I like the mouse pad because I literally just sit at my desk every day because it's like I'm a streamer, so I'm using my computer. I sit basically at my desk from the time I wake up to the time I go to bed. So I get to look at the mouse pad every day. So hey, that's pretty cool. But I fear, my friends, we will never get justice for John O'Keefe. We will never get justice for them because the simple truth is, even if somehow we wanted to bring charges, which the state doesn't because they would lose too much face, so they don't want to. But even if they did, any future defendant would just have Karen Read basically as built-in reasonable doubt. The state blew the play, right? And so they've essentially created all the reasonable doubt any future defendant would possibly need. So short of, a confession, short of an eyewitness who comes forward, short of some sort of major change of the case, and even then, to be honest, even with that, you still would have Karen Read as a valid self-defense tool. So you probably need more than that, to be honest. So I think the odds of there ever being justice for John O'Keefe are basically nil at this point, which is deeply unfortunate, because the state apparently decided to, just barrel through, and they've created all the reasonable doubt any future defendant could possibly want. And whether or not the FBI will do anything is vastly unclear, because the FBI's jurisdiction here is very, very minimal. Their jurisdiction is essentially limited to any governmental official who intentionally deprived someone of civil rights, which is difficult to prove. It's a difficult charge. So their jurisdiction here is very, very small. And so it's very unclear that the federal government can bring charges relating to this. The federal government has no general jurisdiction. They can't bring charges for the murder. They can't bring charges for perjury on the stand. Their jurisdiction is very, very minimal here. Proctor will be the scapegoat, even if that. I imagine that Proctor won't be. No, the jury's going to be the scapegoat, is my bet. Proctor being the scapegoat is a nice idea. Proctor will probably quietly resign and probably go to a different police department if I were a betting man. That'd be the more likely indication, right? He quietly resigns and joins some other police department somewhere. No, what's going to happen if Karen Read is acquitted is that the government is the prosecutor is going to blame the jury. They're going to go forward and they're going to say some combination of, we're deeply disappointed that the jury got it wrong. Those fools. We put on a strong case, and the defense blew enough smoke, and we're deeply saddened that this police officer who is deceased will never get justice, and damn that Karen Read. Probably not quite that strong, but you got the gist. They're going to blame the jury. Michael Proctor may quietly resign with his pension, possibly get a job with a different police department, and that will be the end of that. Yeah, Clemson, go Tigers, absolutely. It was a little surprising there was no rebuttal witnesses from the Commonwealth. That was a bit surprising, to be honest. Proctor should be Brady listed. Yeah. I haven't really gone too much into Turtle Boy. I haven't really gotten very much into that because it seemed like a little bit of a tangential rabbit hole for me. I'm aware that he was apparently assaulted the other night by some of the players involved in this case. But, you know, he seems like a slightly weird character, which, doesn't necessarily mean he's guilty of anything, but, he's a slightly weird character. So I don't necessarily consider him personally to necessarily be totally reliable, but that's just my impression of the man. I'm not saying he did anything wrong or anything illegal, just he rubs me slightly the wrong way, but maybe it's just me. You, of course, if you like him, that's totally up to you. We can have different opinions. Different people will appeal to us differently. It's fine. Karen Reed's legal bills must be huge. Yeah, I'm quite confident it's over $1 million. Her legal bills are over $1 million. I'm quite confident, and it's been a lot. Yeah. Turtle Boy's been a net positive, but also his worst enemy. I think that's even a better way to put it than I did. Yeah, I think that's a very, very fair characterization. He may be a net positive, but if he is, he's his own worst enemy. I think that's a very fair characterization. Can Karen Reed get legal relief from the state? No. No. Karen Reed cannot get legal relief from the state. No. She has no cause of action. No. I don't know if a juror's at the bench. I don't know anything about that. Thank you for the 700 of you who are here. Yes, I rub some people the wrong way. Which, fair enough. Not everyone's going to like everybody. So, some people might think I'm weird. That's okay. I can only be the person that I am to some degree. And hopefully try to become a better person along the way. But, what can you do? Thank you, JPC. What's the ticker clock behind you? It just shows my social media stats. Just a nice way to show people my stats and stuff like that. The clock. If you're asking who makes it, it's Devo is the name of the company. It's called the Pixo or something. It's called the hold on. It's called Devoom is the name of the company. Devoom is the name of the company. It's called the Pixo 64, and it displays pixel art. In this case, it shows my social media stats, shows my YouTube stats, and it shows my Twitch stats, and then displays, you know, cool pictures, because why not? So it's just like a little social media counter. It's neat. I got it for like half off on Amazon. The view count is off though. The subscriber count is correct, 140,000, but the view count is off for some reason. It shows 15.5 million. It's off by about a million. The actual view count's like 16 and change. So I'm not sure why the view count number is off, but it is. So whatever. Am I ready for Supreme Court videos? Yes, we got plenty of those coming up. So good times. No, it has its own Wi-Fi connection. It has its own Wi-Fi connection. Yeah, it's cool. I got it for half off. It was neat, and it's got other like pixel art in there and stuff like that. I will say that the support isn't necessarily the greatest from the company, to be quite honest. For example, it doesn't accurately display my Twitter feed count for some reason, so I don't have that up, and so yeah. Washington State has some sort of form the jury can fill out. That's true. Yes, but not Massachusetts. You're correct. GSD GSDS Dog Mom says, "Embrace yourself. You're fabulous." Thank you. I appreciate that. Why I cover international law? International law is a bit out of my depth. Now, if it's a common law country, then I can kind of get to where I need to be. So if it's any English common law country, then their law is similar enough at base that I can usually figure it out. I mean, it's a quite different from being an expert in the field of law, but that's the nice thing about English common law is that there's enough base similarity that you can kind of cheat, right? You can kind of cheat and you can make sense of what they're talking about. So, but if it's not a common law country, then their law doesn't even have that much going on. So, like Israel and Russia, not as much, right? This is not within my domain. I don't even have enough baseline to like be like, okay, I can cobble together an opinion. So if it's Canada, Australia, the UK, any of the UK, any of the UK states, then they're part of the Commonwealth nations, New Zealand maybe, then yeah, I can cheat. But otherwise not so much. Their law is just too different. It's hard to be an expert of all law everywhere. In fact, it's pretty hard to be an expert of all U.S. law for that matter, especially with our system of government, right? Because we have 50 different sovereign states, and so knowing the intricacies of each little jurisdiction is challenging at best. Plus, of course, there's always Louisiana, which is technically a civil law jurisdiction because the French, and so they're off in their own little universe too. So yeah, I'd probably be slightly more comfortable in doing like the UK than Louisiana, because they're off in their own little world. What do I think about the release of Julian Assange? No particular opinion. I don't know that I saw that there was some sort of deal, but I don't know what the nature of the deal is. No particular opinion. I thought the charges against him were very weak from the U.S. I thought they were pretty weak. At least some of them seemed pretty weak. So some of them seemed unconstitutional. At least there was an argument. I won't go so far as to say unconstitutional. That's too strong. I would say that some of the charges seemed constitutionally suspect, and other of the charges were unclear as to their support. So if for example, the strongest charges against Julian Assange would be that he encouraged or assisted, he was an accessory to an illicit gathering of evidence. So as opposed to just being a passive conduit, right? So the line here legally is if a person just hands you information, then that's fine, even if it's classified information, right? That's on them, not on you, right? So this is how the press gets away with publishing like classified information. This is the Pentagon Papers case, right? That's the Pentagon Papers case and other cases like it. So if they're just handed it to them, that's fine. What they can't do is they can't assist in that. So they can't specifically like encourage anyone to specifically do a specific thing, and they certainly can't assist in it by providing any sort of technical assistance or encouragement or specific inducement. So if that's what Julian Assange did, then that would be a legal problem. But unclear what evidence they had supporting that proposition. And they were trying to charge him for publishing. I think they even had a charge in there at one point. They were trying to charge him for publishing stuff under like the Espionage Act, but that doesn't work. So yeah, when they were trying to charge him with violating the Espionage Act, it didn't really work. But when they were trying to charge him as an accessory, then like maybe, but unclear what their factual support is. Does the civil law mean they won't follow the U.S. Supreme Court precedent? No, they have to. They have to, because Louisiana is still a state. So they still have to follow the U.S. federal law. So, but their state law is weird. So yeah, they're still bound by the U.S. They're still bound by the U.S. Supreme Court, despite the fact that they're technically different legal systems, which is hilarious, right? Because Louisiana is civil law and the United States is common law. So yes, they're a hybrid, and they're weird. And also with international law, to some degree, it doesn't exist. So so that's another thing. Like there really is kind of on some level not there really is not really international law. So it's like can you commenting about international law is a little bit, yeah, there's not really international law to some degree. Um there's only like all the countries in the world getting mad at you and whatever, but to some degree there's not really international law. It's a bit of a floaty construct at best. Unless the UN Security Council does something about it, yeah. Unless the UN Security Council, fair enough. But even then, that's not really, well. That depends, I guess, what you mean by international law. But even then, that's like just the countries deciding they're mad at you, which isn't. I don't know if that's law or not. So much as them all agreeing they're mad at you. But okay. Yeah, I'm not sure. I'm not sure that's just not politics as opposed to law, right? That's the problem. That's the difference, right? Is that really law? It's like, well, if the Security Council takes a vote against you and they decide they're mad at you, is that law? It sounds like politics, because instead of law, but whatever. Testing 2741 says I was expecting Assange to be Epstein if extradited to the U.S. when the fake assault charges were failed in the EU. The rest were First Amendment violating. It's possible, yes. Some of the charges were First Amendment questionable at best. I tend to agree. I read that in the original indictment. I thought some of the charges were questionable at best under First Amendment principles. I mean, like, for example, is the United States bound by international law? I mean, probably not. Because, we have all the military. So, like, is there really international law? As opposed to the rule of power? It's like I have all the power, so I am the law. It's like, yeah. So is there really such a thing as international law? I don't know, man. I'm questionable. When's this supposed to start? It was supposed to start half an hour ago, but we're just killing time and talking. Australia's changed. They'll nab him. That's possible. I can't speak to Australia's interests in this issue. He's a citizen of Australia, is he not? Assange? Or am I having a strong am I having a false memory? So Australia might have some interest in him. I don't know. Yeah. Yeah, I seem to yeah, that's right. He was born in Australia? I didn't know that. Although that wouldn't necessarily make him a citizen of Australia, would it? Do you guys have birthright citizenship over there? It's like it's a very small list these days. So he might have been born there. That may or may not make him a citizen. I don't know the finer points of Australian citizenship law. I can tell you a fair amount about U.S. law. After that, it gets a bit hazy. But I can answer your U.S. law questions for a while if you like, because I like talking about U.S. law because I think it's awesome. I still think the Constitution is one of the greatest political documents ever written, and God bless the founders who gave it to us. It was genius for its separation of powers, not only horizontally by separating power between the judicial, executive, and legislative, but also vertically between the federal government and the states' governments. It prevents any one person or any one entity from being too much of a tyrant. And it was awesome in its construction. Power checks power. It's brilliant. And not to say it's flawless. I have some notes. And also, it's been amended 27 times, so of course it's not flawless. But, hey, it's pretty damn good. Is, it's power checking power is awesome. I remember Antonin Scalia saying about this, about the structure of the Constitution and why it was particularly genius, when he testified to Congress once, and well, he testified to Congress more than once, but on one particular occasion he testified to Congress after he was a justice. He talked about the genius of the Constitution, the structure of the Constitution. He's like, he said, and I think he has a pretty strong point. He's like the real genius of the Constitution is not the Bill of Rights. And he says, like, even Russia has a Bill of Rights, and arguably a better Bill of Rights, right? There's like guarantee, housing, and guarantee this and guarantee all the rest of it. It's like, this is awesome, but it's meaningless. It's a parchment guarantee. It doesn't mean anything, right? So it's like, on paper, the Russian Bill of Rights is arguably better than ours. So the genius of the Constitution is not our Bill of Rights. The genius of the Constitution is the structure of the Constitution with power checks power. And I'm like, yeah, that's pretty good. What do I think of qualified immunity? I don't approve. I don't approve of qualified immunity. I don't think that's correct. The standard should be the reasonable officer. It's the same standard we generally use everywhere else. It's perfectly fine. The reasonable person, the reasonable man. We talked about this, the reasonable man test, right? This is what we use, typically speaking, when we're trying to judge whether or not someone's actions are valid or not. It's like the reasonable man. Will the reasonable man do this? And so I don't approve of qualified immunity. I think Skidmore was the case before qualified immunity, if I remember correctly. And so I was like, let's make Skidmore great again, I've said before, because like basically it's just the reasonable officer test as opposed to whatever it is now. Yeah, I don't approve of qualified immunity. Why won't the charges be pressed on the falsehoods, tampering with evidence? Well, perjury is a very difficult charge to bring because you have to prove that someone knowingly lied. And that's difficult to prove what's in someone's head, right? Unless they make other statements to show it's perjury. But yeah, perjury is a difficult charge to bring because it's difficult to prove someone knowingly made a falsehood as opposed to making a mistake or whatever, right? And even if a person testifies inconsistently, it doesn't necessarily mean they lied because, well, people's memories aren't perfect and people's recollections aren't perfect. So, proving perjury is technically difficult. And so that's one reason. The other reason is because it would cause too much face to be lost by the state. I don't think they want to. And tampering with evidence, again, same problem. How do you prove the tampering with evidence? How do you prove it? How do you prove that someone deleted it? How do you prove it? So that's the challenge. Body cams should eliminate the need for qualified immunity. I don't know if that's true or not. I don't approve in any event. 88% of you say not guilty, 6% of you say hung jury, and 4% of you have voted guilty with 505 votes. Yeah, I always assume there's a 5% base chance of guilty. If you go watch the Law and Crime Chat or the people on Twitter, you can't assume that all of them are trolling because that's just too convenient. You have to assume some of it's real. And, so there is a contingent of the population who is ready to convict because, for example, the defense didn't prove their case. Is that legally a thing? No, it's not. But that's not going to prevent them anyway. Or they just don't like Karen Reed and they're looking for just a reason to say guilty. And so yeah, there's a 5% base chance they convict just because she's sitting there. I think it would be a legal error. I think it would be against manifest weight. I think it would be a massive fail by the legal system. But such things have happened before. There's a reason that we talk about like ideas about manifest weight, because it is occasionally been known to happen that a jury will convict despite basically no evidence. And you can go read the Court of Appeals decisions where the Court of Appeals are like, this is some bullshit. And, there are not a lot of them. It's not exactly every day. It doesn't happen a lot, but it does occasionally happen because the jury just convicts, and it's bullshit. But that's one of the reasons we have appellate courts. But yeah, you have to assume there's some base chance they convict. I think it would be legal error. I think the judge should enter a judgment notwithstanding the verdict. I think the Court of Appeals should reverse. But, what can you do? That's me. Two jurors have been excused. Okay, maybe they're just trying to pare down the jury. I don't know what they're trying to do. Yeah, I think the odds for an appeal are very strong. Trying to argue manifest weight is typically basically a loser argument. It's very difficult to prove that. It's very difficult to make that argument because the jury is the one that gets to weigh the facts. So basically, the question is, could any reasonable jury, by any reasonable combination of facts, conclude guilt? Right. Once the verdict is guilty, because the key there is to remember that you're presumed innocent until found guilty. So if she's found guilty, the presumption of innocence no longer applies because she's been found guilty. So it's not enough to say, so all the presumptions flip, right? The presumption until the moment of conviction is innocent until proven guilty. Once she's convicted, the presumption is she's guilty. So when you're on appeal, you can obviously argue for legal error. The judge made a legal mistake, and that's your more typical argument. Or you could argue for ineffective assistance of counsel, but obviously that doesn't apply here. These are very effective assistance counsel, so that doesn't work. So then your only other argument other than legal error, like the judge admitted something they weren't supposed to and all the rest of it, your only other option is to say, okay, the jury got it wrong. But since the jury is the finder of fact, and now you're presuming guilt, you don't have to say, is there reasonable doubt? That's no longer the right answer. The right answer is now, could any reasonable jury, through any reasonable arrangement of the facts, come to the conclusion of guilt beyond a reasonable doubt? Because the jury is allowed to ignore or diminish evidence, right? Because no case is perfect. I mean, it's very, very unusual for a case to be incredibly rock solid, right? It's, where we caught it on video and there's a confession and, a written confession in blood, and, they told a friend and there were 10 witnesses, and, that's not the typical case. So, to say, oh, there's doubts, that's typically true. That's not enough anymore. The question is, on appeal, could a reasonable jury convict? Is it possible? Could the reasonable jury believe the one perjurer over the 10 nuns? Yes, they probably could, right? Because it's up to them. I mean, if they knew those things, right? Did they know that the one person was a perjurer? Did they know that? And did they know that other 10 people were nuns? Did they know that? And did they find guilt because they believed the perjurer over the 10 nuns? Then if they knew all those things, then that's probably a valid verdict because they knew everything. Right? They made an assessment that in this moment the perjurer was more credible than the 10 nuns. But there does come a point in law where you're like, okay, this is just against manifest weight and no reasonable jury. And I do think you can make that argument here because, well, for all the reasons we pointed out, it's just too much. It's too much. It's against manifest weight. But it's a very difficult argument to make. Not for the least reasons that Court of Appeal judges are not particularly thrilled to overturn jury verdicts. Because, well, that's our system. We have a jury system for a reason. And so they're somewhat loath to, change the verdicts of jury, which I suppose are understandable enough as far as it goes. So, but I do think you can make those arguments here. Jury number 3 was dismissed. I mean, okay, fair enough. That's cool. I don't know why, but fair enough. All right, we're back. Except we let 9 lawyers in robes decide everything. Well, they decide questions of federal law. That's their job. Who overrules them? Depends. If they're making a decision based on statute, Congress does. If they're making a decision based on the Constitution, the people do. We talking JNOV? We're talking JNOV, and we're talking like the Court of Appeals. Yeah. Yeah, we're talking JNOV basically, and you're correct. It almost never happens. You're absolutely correct. It's very, very rare. But if there were ever a time, this would be a good one, you know? Thank you for saying the shirt is pretty. I appreciate that. Don't alternates hear clear closing statements? Not sure how this jurisdiction does it. Different jurisdictions do it differently. But I think this juror was excluded for reasons other than that. I think they were excluded for cause. But maybe I missed what's going on. Yeah. Congress can pass new laws if the Supreme Court's wrong about the statute. Yeah, exactly. So if the Supreme Court's decision is statutory, Congress overrules them. If it's constitutional, the people overrule them. Yeah, that's who. Don't like that Bev gets to pick the foreman. Yeah, I find that to be a bit odd, but that's how this jurisdiction rolls, which we saw in South Carolina too. It's just how they roll because, well, I don't know, reasons. Jenna staring daggers. Yeah, a bit. Oh, that's fair. No problem. Sometimes it's difficult to know who's talking to who. So if I read a chat and I assume it's talking to me, then and it wasn't meant for me, then fair enough. But sometimes it's very difficult to know who's talking to who. So yeah. Thank you for saying I look great. I appreciate that. Someone give Paul O'Keefe a helmet. Have you missed anything? No, I've not missed anything. They've just been hanging around. Can someone explain to me the lady who sits by the witness block? She's the clerk. Why does she have that thing over her mouth? It's to capture her voice. She's the stenographer. So, but instead of using the machine where she types, this court does it by voice. So she literally repeats everything that she hears, and that's the official transcript. That's what it is. She's transcribing it by repeating everything into the machine. I think it looks pretty weird too, but that's how they roll. Yeah, she's the stenographer. I'm not sure if stenographer is the correct term here, but that's what she is. Do other court microphones also go into the official court proceedings? No, she's the official record. That's what she does. Yeah, she's the official record. So no. Court reporter. There you go. Court reporter. Fair enough. Yeah, I don't really know why they do the vocal thing. I think it looks incredibly weird, but that's what they do. Why don't they just use the microphones for record keeping? Seems more efficient. Don't ask questions like that. don't ask questions like that. Does she transcribe the sidebars? She certainly does. Yes. Yeah, she certainly does. Seems like an awful job. Yeah, I mean, you literally are just talking constantly. because you're just repeating everything you hear. I think it's a pretty bad job to be honest. Yeah, basically it's a dictaphone. Basically it's a dictaphone. You got it. Is there any check on the court reporter's accuracy? Um, yeah, in so much as the attorneys can get copies of it, and I assume there's some process to correct it, but you know, it is what it is. I wish they would get started, to be honest. I'm having trouble filling the time. I will answer your generic U.S. legal questions until such time as they come back. I'm glad you've grown to love me. That's very kind of you. I'm very happy that so many of you are here to be with me to talk about a subject I genuinely love, in case that was not readily apparent. I love this stuff. I think it's great. I love thinking about it and I love talking about it. And it's very cool to have a place where I can just talk about it all the time. That's awesome. There's really no real world equivalent for this. And I really do appreciate that you guys are here and that you can just listen to me talk about a subject I love. Do I think all of Trooper Proctor's previous cases will be re-examined? I think that there are many attorneys out there who are filing many motions relating to this. I think that's definitely going to happen. Do I cover other cases? Sure. Typically not trials. Trials are not typically my main thing, although they have obviously been a dominant thing now. But yeah, that's more sporadic. But I will cover the Baldwin trial, which is coming up very soon too. So we're going to move right from one trial into another, which is kind of hilarious for me because that's just not typically what I do. But yes, my typical practice or my typical interest is more appeal, because appeals are about law. Trials are about facts. Appeals are about law. Trials are about who, what, when, where, why, right? They're about who did what to whom and when and blah, blah, blah. So they're about facts. Appeals are about law, right? They're a pure legal exercise. It's like you take the fact as a given, and then you just think about the law. And I find that more interesting personally. I find appeals more interesting because it's more intellectually pure. I suppose would be a pretty good way of thinking about it, right? It's just more of an intellectual exercise. It's because you're just thinking about the law as a much more distilled concept, and I find that more interesting. So I like the U.S. Supreme Court. I cover their cases. They're coming out with a lot of very interesting stuff in this, and I'm looking forward to covering it pretty soon. Yeah, facts are messy. Yeah, just tell me the facts. I'll tell you the law, right? Yeah, appeals are more interesting to me. Where's my 100K plaque? Right over my shoulder. It's right there. My 100K plaque is right over my shoulder. It's right on the screen. I'm excited for the debate. Not particularly, no. Not particularly. The salt lamp I do like. It glows and I like it. It's nice. The bump stock ruling was as I predicted? Yeah. Yeah. I was a little bit surprised by the vote, but yeah, it was basically what I predicted, right? It's a straight statutory issue. It's like it's just not supported by the statute. It's like, yeah. The other one that no, the bump stock was as I predicted on the vote. The bump stock was I got on the vote. The one that I sort of missed on the vote was the domestic violence restraining order one. I'm not even sure if I predicted that one. Well, no, I don't think I did, because I said it depended on the history, and I just didn't know it well enough to know for sure. But that the vote caught me a little bit by surprise because it was 8-1. I read the decision, or at least skimmed it, and I'm like, yeah, that makes sense. So I haven't really had a chance to discuss it, but I thought the decision made sense. Because it's like, yeah, they're asking the right question. So, yeah. My parents are, in fact, proud of me. Do I have a Patreon? No, I do not. I don't like Patreon as a entity because they've taken decisions against creators that I do not approve of. And so I do not have a Patreon, but we do have other ways to support it. You can always subscribe here on YouTube itself. So that there's that. And if you want to donate otherwise, we accept Venmo and Cash App and some other things. And the bot from time to time should provide you those links. Will suppressors follow? Mm, probably not. I mean, I don't think that's the next logical step in the sequence. You know, it's like as I'm trying to think about what the next logical step when it comes to gun rights are. Um, yeah, they're looking for something relatively smaller. I think suppressors and silencers are not the next logical step. Steve Gosling did move to the prosecutor's office. You're correct. Did the bump stock case come about because of Las Vegas? Yes, it did. Yes, it did. I predict regulars will be regular for some time. I tend to agree. All right, I need to take a brief personal break. So I'm going to allow you to look at the spinny fan for a while and enjoy the spinny fan, and I will return uh, promptly. Hopefully, the court will not start without me, but if it does, we'll do what we can. I'll be right back. Please enjoy the spinny fan.
persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court in and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed.
All right, good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. So I don't know how many times I start in the morning by saying we appreciate your patience, but today is one of those days. Again, we appreciate your patience. You may notice that one of your fellow jurors is not sitting with us today. I can assure you that that is because of an issue that is just personal to that juror and has nothing to do with any concern of any of you, so please disregard that, okay? I do have to ask you those 3 questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So now we're at the point of the trial where the lawyers get to do their closing arguments for you. I've given them each an hour to do so, and they both tell me that they want me to give a 5-minute warning. I just don't want you to think I'm scolding them when I give a 5-minute warning, so we'll let them do that. When I was a trial lawyer, I tried a lot of cases in this courtroom. The thing I liked least about the trial was just before I stood up to give my closing argument, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. So because of that, you have to put your notebooks away. All right, so if you just put your notebooks away and just listen, and though the closing arguments are not evidence, they're certainly a very important part of the case. And you've all seen how hard the lawyers have worked for this long period of time. We've all noticed that you've paid great attention throughout the entire trial. I'd ask that you extend your courtesy to the closing arguments. And in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last. So we will hear now from Mr. Jackson.
All right, guys, here we go.
Thank you, Your Honor. Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way.
Nice.
Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America. Lest the government stop answering to us and we start answering to the government.
Nice.
And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions.
Poetic.
What does that mean?
Nice phraseology.
It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple.
Not bad.
You'll surely say to yourself, I don't want to believe it. I don't want to believe that can happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we?
All right, let's count them.
Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether.
Nice.
Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody.
Yep.
Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage.
Nice.
Hide personal relationships. Make this case cut and dry and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you.
Very nice.
But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Reed and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up until the time Karen Reed dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble.
Fair point.
Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And then when he was caught and asked to describe that man, he had to. It was a little bit vague, but you remember what he said. He was tall, with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial that was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data, look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monotonic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she'd left.
There you
So
go.
don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. Also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie, and Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 1229 to 1250. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 1230. Had to be in order to connect to the Wi-Fi at 1236. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial.
There's a lot of butt dials,
How are those
man.
lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone? Missing. Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They had been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You could see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me?
Yep.
Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his in testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, you know, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done.
Yep.
What's that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First he said it was administrative work, then he said he was moving cars, then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted, yeah, I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years.
Preach it, baby.
Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth.
True.
But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day, at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now that call is odd and suspicious enough, in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing.
Nice.
But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold.
Yeah.
That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was no body on that lawn.
Preach it, baby.
Period. At 2:30 a.m. And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about with a Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John, he walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back, he's not responding, minutes start to pass, 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad.
Nice alliteration.
She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up, she's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears are realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her, you can feel the grief, you can feel the raw anguish, you could see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body.
Yeah, preach it, baby.
Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief.
Yep.
So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse. and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can
Preach.
see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if
Nope.
there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn officer. He's not associated with Canton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barrows' description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV.
Preach it, baby.
And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out
They
loud.
sure did. They sure did.
But still, you've got to imagine that the Alberts had to be stressed, what with that whole thing about a dead body being on their lawn. That might get some attention, and they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too.
Yep.
And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall.
Yeah, all right.
A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case.
Let's look at Michael Proctor,
One of the
indeed.
consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth, or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Loughran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report.
There you go, baby.
He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, one, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass?
There you go, baby.
Michael
There you go.
Proctor.
Yep.
So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math.
Yep.
That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside.
Yep.
That would be a magic hair indeed. That magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered.
Yep.
No blood was found anywhere on that taillight or any taillight pieces.
No blood.
No tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight.
Mm-hmm.
While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally. That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers, very early on, who searched the scene. None of them, not a single one, found any taillight material at the scene. 0.
Preach
Stephen
it.
Seraph, Sean Good, Stephen Mulaney, Michael Lank, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet, and they even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found. About 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about, those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not Stop and Shop bags, thank God. At least they moved up from that. They've even got evidence tape on them. Who knew? Evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. And I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes.
Nice.
Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37. And see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara, unidentified troopers and Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, and now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses, and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts, that's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house, that SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto-pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but two thoroughly credentialed medical examiners, or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident.
That's a lot of credentials, man. I'm just saying, that's a lot of credentials.
However, with a physical altercation.
Yeah.
In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rentschler, mechanical engineer and a biomechanist. They reviewed this case, they did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony.
I do. Sadly,
I think I'm being kind when I say that Trooper Paul's analysis lacked credibility.
Yeah.
Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement before coming to his final resting place with his unbroken phone tucked neatly under his body.
Yeah.
It's nonsensical. It borders on laughable. Compare that testimony
I wouldn't
to
say
Dr.
borders
Dan Wolf
on.
and Dr. Andrew Rich. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rinchler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, "You can't deny the science and the physics." John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way,
Very good question.
before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour.
Preach it, baby.
And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision.
Nice shade there on Paul.
That
Like that.
3.5-ton
That was good.
SUV entirely with his right arm, launching him some 30 feet.
The Commonwealth's best and
Amazingly,
brightest.
the arm suffered
Nice.
no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised in the covering up. But as-
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while
Nice
looking
word
for the naked
choice.
pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat. Talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object, and he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you, not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies and the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth, and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt and to a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
Right.
Okay. Well, outstanding close. Fantastic. It was his opening might be slightly better, but we're nitpicking, right? Yeah, like that sort of like the soft opening of his open was better than the soft open of his close. I found the soft open of his close slightly more muddled, but otherwise it was essentially flawless. And I really liked the storytelling. He's a very good storyteller. He's also very good with the imagery and his word choice. He is a master of words and evocative imagery, and he brings things to a very nice focus. And he's just like using all this language in a very, very masterful way. It's an outstanding close. And anything beyond that is just anything beyond that would just be I like a different style, right? So anything beyond that would be like I like Chinese food more than I like Mexican food. It would be something like that, right? So I also liked relatively in the beginning, in the beginning, after he sort of did the soft open, very shortly after that, maybe 5 minutes after that, he kind of did a list of all the reasonable doubt things. I really liked that moment where he just kind of listed them one after another. I wish maybe that had been slightly more spelled out in some way. Maybe it had been enumerated in some way, like he did 1, 2, 3, 4, 5, like he had actually numbered them in some way to make that point a little bit easier rather than just being a flowing list. So they might have punched a little bit better rather than just being a flowing list. But that's like stylistic. It's like it's a stylistic issue. I might have preferred this as opposed to this, but essentially flawless close. He was very good, and then the judge gave him 5 minutes left, and he was very good at essentially figuring out where he needed to go to finish it out, because it looked like he skipped a page because he was running out of time, but he knew kind of where to go, and he knew how to sort of close the case and finish that out, which that takes a little bit of discipline and skill. So It was a fantastic. He's he might be the best attorney for the most consistent throughout, right? We could find attorneys we like different for different things. We could find, pieces we like different, but he might be the most consistent attorney throughout. His attention to detail in particular is perhaps the best we've ever seen. I don't know that we've ever seen anyone who's so good at with just pure attention to detail and also illuminating that attention to detail and bringing out the detail and providing the detail. Also, I really liked the minimal use of the exhibits. I thought that was very good. He just used, and the exhibits he used were just to prove a small point, right? This is the tail light at 5 a.m. It's obviously intact, right? And so that just collapses their case. So I did really appreciate that, and his delivery, his consistency of theme from the opening that this is a frame job. He continues to basically make that argument, and he illuminates it very well. I did appreciate the digs at Paul in particular. The Commonwealth's best. That was a nice little touch. The digs at Proctor, having access to the tail light, how they didn't find the pieces. The red Solo cups did not make an appearance in this close. That's disappointing. No red Solo cups, but the shop and stop bag did make an appearance. So I guess we'll give one out too for that. So yeah, all those things are fantastic. So, it joins the pantheon of great closes. And he might be the most consistent attorney throughout. Plus, also, I really enjoyed that he took a moment to preempt what he imagined would be the state's close. He's like, because I know they're going to say the ground was frozen and that's some bullshit. So he took the time to highlight that and say that. And so he took the time to telegraph that. And even if the state doesn't mention it now, even if the state drops it and doesn't mention it, he still got the point across. So either way, he's covered. That was a very sharp moment. So I do appreciate that. Exceptionally well prepared, exceptionally well thorough, outstanding storyteller, fantastic use of vocabulary. Perhaps slightly could have used a little bit more signposting, so the transition of the story could have been a little bit cleaner. If maybe it flowed too cleanly. Maybe I would have liked a little bit more explicit delineation, but how much nitpicking can I possibly do? And at that point, it's just like, it's stylistic, right? So, but otherwise it's like, yeah, I can't, if I take his speech and I rewrite it, because we sometimes do this exercise, right? We'll take an argument and we'll rewrite it because we hear shit and it's like, let's make it better. If I took his and tried to rewrite it, it would just wind up sounding 95% the same. And that would largely just be me injecting my style rather than his style, right? So and whose would be better would be in the eye of the beholder. So essentially flawless, fantastic. Okay, Commonwealth, let's see what you have. This should be really, really good. Really, really good. All right, let's see what you got. All right, let's do this thing.
Thank you very much, Mr. Jackson. All right, Mr. Lally.
Thank you, Your Honor.
I thought Lally wasn't going to close. I thought you guys told me Lally wasn't going to close. Didn't you guys tell me Lally wasn't going to close? You guys lied to me. All right, let's hear from Lally. If you have a caffeinated beverage, you probably should have it nearby. All right, guys, let's do this thing. All right. Maybe he'll get better. Maybe closing is his thing.
I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nuttall. He was trying to bag valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened, and the defendant said, I hit him, I hit him, I hit him, I hit him.
Okay.
Firefighter Anthony.
All right, I'll give him this. Strong start. Strong start. So hey, this so far is the best of Lowley we've seen. So hey, maybe it'll stay maybe it'll stay okay. All right, let's see.
Flamati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, "I hit him. I hit him. Oh my God, I hit him." Firefighter Katie McLaughlin was tasked by Firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant, and the defendant said, "I hit him," repeatedly. Firefighter McLaughlin asked for clarification. "You did what?" And the defendant repeated, "I hit him." Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, "Could I have hit him in the car while they're on the phone with Ms. Roberts going from Ms. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him?" Once on scene, once asked, as Ms. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, "I hit him."
Okay.
You heard testimony from Officer Sarif, statements that he attributed to the defendant as saying that morning, "This is all my fault. This is all my fault. I did this." This is what the defendant is saying on scene. Since then, stories changed a little bit. But those were the words that came from the defendant's mouth on January 29, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things.
Little
What I would
things?
suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. And I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case.
Okay.
Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case.
Yeah.
It's essentially defense by obfuscation. It's a three-card money trick. The facts and the evidence in this case are your card. They're the Queen of Hearts. And so what I want you to, or what the defense wants you to do, is not look at that card. Look at anything else. Look at the movement. Look at this person. Look at that person. Look at text messages. Look at this. Don't pay attention to the facts and the evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the three indictments before this court. The evidence and the facts of this case are for you, the jury, to decide. Using your common sense, using your life experiences as your guide through that as you go. Before I turn to that evidence that I will submit to you ineluctably demonstrates the defendant's guilt, let me first just address Trooper Proctor. The text messages from Trooper Proctor are unprofessional, they're indefensible, they're inexcusable. However, as distasteful as those messages are, and their content is, I submit they had no bearing whatsoever or impact whatsoever on the integrity of the entirety of the investigation that Massachusetts State Police collectively conducted into John O'Keefe's death here.
I suppose that could be technically correct. I suppose that the text messages did not have any impact on the integrity of the investigation because there wasn't any. So I suppose technically correct, best kind of correct. All right.
As was asked of Trooper Proctor on cross-examination, these were texts from his personal phone that he never thought would see the light of day. He was asked whether or not he ever thought that he would be asked about these in a courtroom. put to him in sort of a safe space, a safe place for him to discuss, if you will. What do you not see in those text messages? You don't see any discussion or any illusion of any conspiracy, of any framing of the defendant, of any planting of any evidence. No evidence.
That's true. They
whatsoever.
didn't do it in text message. I'll give you that, I
Why?
guess.
Because it didn't happen. There is no conspiracy, there is no cover-up, there is no evidence of any of that beyond speculation, rampant speculation and conjecture on behalf of the defense. Two things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional, there's no defense to them. And the defendant killed John O'Keefe.
Okay.
Turning to the evidence, let me first talk a little bit about John O'Keefe. You heard a lot about him over the course of this trial, about his selfless story through his family and friends that loved him, including his adopted niece and nephew. You heard a lot about the lives he touched and the different people who he had friendships with. You heard a lot about from those particular friends and from his family. Turning to what I would submit to you as a timeline. This may be a little hard to see up here. What I'm going to go is from left to right. January 28th, 2022, 9:49 in the morning, Karen and John begin fighting over text messages. 2:25 p.m. in the afternoon, the defendant texts Mr. O'Keefe, "Tell me if you are interested in someone else. Can't think of any other reason you've been like this." John texts back, "Nope." 2:25, Mr. O'Keefe texts the defendant, "Things haven't been great between us for a while. Ever consider that?" This is also testimony that you heard through multiple sources, whether it be phones, whether it be from the children, whether it be from other friends or family members as to the relationship in the months and weeks leading up to John's murder. 2:32 p.m. John texts the defendant, "Sick of always arguing and fighting. It's been weekly for several months now." He then texts the defendant, "OMG, stop calling." And this is during the time frame that Trooper Garino was talking about, with 18 phone calls, most of which were rejected, some of which were missed, and a couple of which were answered over the course of this afternoon, as she's continuing to needle and try to engage him in a fight that he doesn't want to have. 2:33 p.m. The defendant texts John, "So you're not into this anymore." 2:34 p.m. John texts the defendant, "I am not answering, stop calling." The defendant then texts John, "Then stop starting with me." 2:38 p.m. The defendant texts John, "I'm going to grab a drink in a bit." At 2:38 in the afternoon. Around 3 p.m. is the testimony you heard from Erin O'Keefe in regard to the defendant texting her, asking if she can go out without her husband, Paul. Asking to go out for a drink. This is while Erin O'Keefe testified she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon. This is also the point in which the defendant says to Ms. O'Keefe, "Wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's, with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy's. Vodka soda, tall cylinder glass, lime, and a straw. 9:13 p.m., drink number 2. 9:20 p.m., drink number 3. 9:33 p.m., drink number 4. 9:57 p.m., drink number 5. 10:22 p.m., drink number 6. 10:29 p.m., drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's. The drink that she indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall, which several individuals at the waterfall testify that she produced from her coat when she walked in, and that you can clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass in her right hand. Now, understanding that some of these drinks are not the full tall cylinder drinks, what she's doing is she's getting shot glasses of vodka and then pouring them into the drink after she's consumed the drink. 10:54 p.m. The defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, about an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m. From the waterfall video, you have Ms. McCabe, Ms. Colakithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Nicole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with a cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, "Where to?" 12:14 a.m., based on the fact that she's driving, and Ms. McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe and speaks with him regarding directions, sort of going over which way to come in, Chapman Street, over Cedar Crest, as far as coming into Fairview Road. 12:15:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:17:56, the defendant drives by the Temple Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regard to the CSLI data and the ranging data in reference to it coinciding with what you observed, the black SUV, from each of those respective videos. 12:19:32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a 3-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time at 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxon, and Ricky D'Antono pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32 and 34 Fairview Road, where his body is discovered the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Ms. Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. What you have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle. The movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up, moving up, moving up, as the witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota text stream, which you now have up on the screen before you here, indicating that following that 3-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, for 24.2 miles per hour for 62.5 feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m., you have that second triggering event 8 minutes after the 3-point turn when the vehicle is in reverse at 24.2 miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at 1 Meadows Ave, Mr. O'Keefe's home. 12:37 is when the defendant leaves this voicemail. So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62.5 feet, the defendant leaves that voicemail seething in rage as she's screaming, "John, I fucking hate you." 12:40 to 12:42. Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. If you recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:55. The defendant texts John, "See you later." 12:59. The defendant calls, leaves another voicemail for Mr. O'Keefe. Exhibit 637. It sounded like this.
"John, I'm here with your fucking kids. Nobody knows what the fuck you want, you fucking pervert."
But somebody did know where Mr. O'Keefe was. The defendant knew exactly where he was. She had driven him there, she had struck him there, she had left him to die there. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, "Your kids are fucking alone." 1:09 a.m., the defendant texts John, "I'm back in Mansfield. The kids are home alone." She's not. GPS, as far as it never disconnects from the Wi-Fi until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point. 1:10 a.m., the defendant calls her parents. 1:11 a.m., she calls Mr. O'Keefe and leaves this voicemail.
"John, I'm going home. I cannot babysit Amy. I need to go home. You are fucking using me right now. You're fucking another girl. Kim's sleeping next to me. You're a fucking loser. Fuck yourself."
1:18 a.m., the defendant leaves another voicemail. Now, about 1:43 or 1:45 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or any body to be out on the front lawn. 4:42 a.m., the defendant calls and speaks. The calls to her parents are finally answered. 4:49 a.m., the defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:53 in the morning is when the defendant instructs Kaylee, Mr. O'Keefe's niece, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight, and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe and where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, "John's dead, Kerry, 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 Kerry," hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead, he must have been hit by a plow. 5:07 a.m., the defendant leaves One Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Kerry Roberts. Ms. Roberts starts calling hospitals, calling KPD, calling 911. Something that you would do if you didn't know where Mr. O'Keefe was for all of these hours, that all of these other phone calls are being made and these text messages are being sent and calling your parents and all of these other things. No calls to 911 from the defendant.
Well, no.
While John O'Keefe is laying.
I don't think you would necessarily call 911 just because you didn't know where someone was. That seems a bit odd. Yeah, any person would call 911 immediately if they didn't know where someone was. No, I'm gonna say no on that one. Okay.
Freezing and dying from a brain injury and a skull fracture on the front lawn of 34 Fairview Road. 5:11 a.m., the defendant's vehicle is seen on the Canton Library camera heading towards the waterfall. Seems to be sort of retracing the steps. 5:18 a.m., the defendant's vehicle is seen at Washington Street and Chapman on the Temple Beth Abraham video, heading in the same direction that it was the night before when it was heading to 34 Fairview Road. 5:35, is when the defendant arrives at Ms. McCabe's house. Ms. Roberts arrives shortly thereafter. Both of them see the broken tail light at that time in the driveway. Now that gap of 5:18 to 5:35 is way too much time to be driving from the area of the waterfall to Jennifer McCabe's house. And as I indicated a moment before, heading in the same direction, same directionality, retracing the steps from the night before, heading towards 34 Fairview Road. Why is it that the defendant can see Mr. O'Keefe when they eventually get to Fairview Road and no one else can? It's because she knew exactly where he was. She had hit him and left him there the night before, and she had gone back during that time frame between 5:18 a.m. when she's seen on the Temple video and 5:35 when she arrives at Ms. McCabe's house. 5:33 is when the defendant, Ms. McCabe, and Ms. Roberts return to One Meadows Ave searching for John. 6:03 is when the defendant, and no one else, spots Mr. O'Keefe's body buried in the snow. Exhibit 12, indicating this cruiser camera video, which I know you've seen a dozen times. So where I'm starting it from this point in this card right here is the spotlight that Officer Saraf had to use in order to locate, even with a vehicle of Ms. Roberts parked right in the middle of the road. In the darkness, in the snow, in the blizzard, in those conditions, the defendant, sitting in the back seat of the vehicle, knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian witnesses, from the first responders. But the defendant knows exactly where he is. 6:07 a.m., Ms. McCabe calls 911. 6:08, the defendant leaves that 4 or 5 minute voicemail, leaving the phone in the car for some reason to Mr. O'Keefe's phone. 6:23 and 6:24 in the morning is when Ms. McCabe conducts those Google searches. 7:50 in the morning is when Mr. O'Keefe is pronounced deceased at Good Samaritan Hospital. 4:13 to 4:20 p.m. is when the defendant's SUV is towed from her parents' house in Dighton. 5:20 p.m. is when the search team arrives in the area of 34 Fairview Road to conduct the search for evidence. 5:30 p.m. is when the defendant's vehicle arrives at the Canton Police Department Salad. Let's circle back for a moment to Mr. O'Keefe, to his families, to his friends, and to his relationship with the defendant. You heard testimony from Paul and Aaron O'Keefe that they liked the defendant, that they thought he was good for John, thought he was good for the kids. All outward appearances of the relationship were good. You heard testimony from the children that that was not true behind closed doors. But Paul O'Keefe testified that he told the defendant's parents this, that he liked Miss Ruth, that he thought that she was good for John, thought that she was good for the kids, weeks before John's murder. He even blew her a kiss in the emergency department at Good Samaritan as he was walking out and she was still being treated while they were there. Invited her over to John's house to grieve with him. Invited her to sit down with him while he explained to their nephew Patrick about John's passing. The defendant shows up at the house. Abruptly goes upstairs with her father for a period of about 15 minutes, which is about half of the time that she spent there that morning grieving with the family. She left with a bag of her belongings, drove with her family there, and then took an extra vehicle in the height of the blizzard now, around 1 o'clock in the afternoon, drives that vehicle all the way from Canton, where it was parked at her boyfriend's house, where she stayed over on many occasions, drove that vehicle or felt the need to drive that vehicle from Canton all the way down to her parents' house in Dighton at the height of the blizzard. You heard testimony from Aaron O'Keefe of the text messages and the phone call on January 28th. heard that Erin O'Keefe called the defendant on the morning of the 29th because she was concerned for her. She wanted to know what was going on with someone she considered her friend. The defendant yells, "John is dead." Ms. Robertson grabs the phone and then updates Erin O'Keefe as to what's going on with John. Erin O'Keefe again calls back later because she's concerned for someone that she considered her friend. How does the defendant respond? These are some of the little things. The defendant indicates to Ms. O'Keefe that she just has to remember the bad times and indicates to her, "I don't think I'll ever see you guys." This is after she's done her quick in and out at One Meadows Ave and is now with her parents or with her father, driving that car, essentially taking the murder weapon from Canton and bringing it down to her parents' house in Dighton. She's indicating over the phone to Erin O'Keefe, "I don't think I'll ever see you guys again." Why? If she didn't kill John, why would she say that? You heard a lot of testimony about New Year's Eve in Aruba. You heard the testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. And then the defendant telling Erin via text message that she caught Johnny kissing Laura's sister in the hotel lobby. She got into an argument about it, and then they never met up. Meaning the defendant, Mr. O'Keefe, got into an argument about it, and she and Erin O'Keefe never ended up meeting up in Aruba. You heard testimony consistent from Laura Sullivan, Marietta Sullivan, as well as the children. The kiss never happened. It never would happen based on the relationship, the godfather relationship that John O'Keefe had with Laura Sullivan, her family, and particularly Laura Sullivan's child. The defendant persists with this unfounded suspicion and accusations of infidelity in her text messages with Mr. O'Keefe, in her text messages with Mr. Higgins, where she's accusing Mr. O'Keefe of making out in the lobby with Marietta Sullivan. Both of the Sullivans and the children have the defendant and Mr. O'Keefe following this incident with Marietta Sullivan going into a room. Both of the children testified that they're in that room for about 20 to 25 minutes and they're arguing about the defendant indicating that Mr. O'Keefe kissed someone in the lobby. And you have Laura Sullivan's testimony about 20 to 25 minutes after her sister comes out and states her displeasure about the defendant. It's about 20 to 25 minutes before Mr. O'Keefe comes out, and then he and Ms. Sullivan have a conversation. Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy and he needs to take this and goes off from there. Ms. Sullivan has later conversations with Mr. O'Keefe on this Aruba trip, asks him if he's okay, asks him if he's happy. She indicated in her testimony that Mr. O'Keefe shrugs it off and says it is what it is. You heard testimony from the children about the arguments in the weeks and the months. And I know this is a displeasure to the defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece Kaylee, John tried to diffuse, he tried to walk away, and the defendant would follow each time, during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. That Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to see if McCarthy is eventually the waterfall, and the defendant killing Mr. O'Keefe in the early morning hours of January 29th. We have the testimony in regard to the ring camera. Kaylee indicated in her testimony that John had had that for about a year. So during the course of 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code to the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did the quick cleanup upstairs with her father, upstairs in the home, Neither of those devices had access to the Ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regard to the romantic kiss that she placed on Mr. Higgins earlier on January, whatever it was, during the Patriots game. Mr. Higgins, who Mr. Jackson was indicating weren't very good friends with Mr. O'Keefe, but had been invited over to his home for a Patriots game, in which time the defendant escorted Mr. Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only two videos missing from that Ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts the broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video of that. The variety of stories that the defendant tells on the morning of January 29th. There were text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. The defendant calls Katie Camerano. The defendant calls her parents at 1:18 in the morning, 4:38 in the morning, 4:42 in the morning. The call then from Kaylee's phone to Ms. McCabe, because the defendant didn't have Ms. McCabe's phone number. Both Kaylee and Ms. McCabe indicate that the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies she starts to call her Julie Albert, because Chris Albert, Julie Albert, they live close by the waterfall. Maybe that's where he went. As the phone is ringing, and this is a phone call that both Ms. Albert and Ms. McCabe testify was never answered. As the phone is ringing, her husband Matthew McCabe reminds her that they saw the defendant and Mr. O'Keefe and the car outside of 34 Fairview, so she hangs up. During this call, or during these subsequent calls, the defendant indicates to Ms. McCabe, maybe I hit him, did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a plow and that he's dead, and then indicates further that she's drunk and doesn't remember. She tells Ms. McCabe about the cracked taillight before they even get in the vehicle and go anywhere, as you recall the testimony of Matthew McCabe, indicating that he had some concerns about them driving around in a vehicle with a damaged taillight in the middle of a blizzard. Ms. Roberts' testimony that she saw the broken taillight in the driveway at Ms. McCabe's house, and that it was consistent with what she observed in the photographs that were shown to her of it later in the Sally Port at the Canton Police Department garage when the search warrant is executed on February 1st. You have the text messages between the defendant and Laura Sullivan from January 29th, in which the defendant indicates to Laura Sullivan that John is dead, indicates that we found him in the snow at 5 a.m. And every indication is that he was found in the snow by the defendant, Ms. McCabe, and Ms. Roberts around 6 a.m. 5 a.m. would be about an hour before. 5 a.m. would be between that time where the defendant is unaccounted for, heading in the direction of 34 Fairview Road, 5:18 and 5:35. Little things. The defendant asked Ms. McCabe to Google how long to die in the cold. She did so at 6:23 and 6:24 in the morning. You have the testimony of Ms. Hyde and Mr. Whitford as to SQLite databases, P-list databases, Knowledge C databases, state DB tabs, as far as all of that. Also from Trooper Garino as well. These searches were unequivocally done at 6:23 and 6:24 in the morning, and not at 2:27 and 40 seconds in the morning. They were not deleted by a user. That is not what deleted means. Frankly, Mr. Green, the last question that I asked Mr. Green is, was he aware that Sellbright, and by Sellbright, the person who designed that being Mr. Whiffen, had to alter exactly how their software worked because of people like Mr. Green misinterpreting the data as he did in this case. And What did Mr. Green say? Yes. But those questions, as far as how long to die in the cold, I would submit mirror the questions that the defendant asked firefighter Whitley in the back of the ambulance, if you recall those. She asked firefighter Whitley how long to die in the cold without a jacket. She knew how Mr. O'Keefe was dressed. She knew when she left him to die in the cold how he was dressed. The defendant made statements to firefighter Becker that the last time that she saw Mr. O'Keefe, they were in an argument. Again, in the back of the same ambulance as firefighter Whitley. You have testimony from firefighter Woodbury. Same kind of questions. If Mr. O'Keefe could be alive without a jacket. You have the testimony from each of these firefighters as to sort of the vacillating emotional state of the defendant that morning. What you have in the testimony from firefighter Woodbury is that despite all that, there were no tears that he observed from the defendant at that time. What each of those first responders indicated is that the defendant repeatedly stated, is he dead, is he dead? Not is he okay, is he going to be okay, how is he, any sort of questions about the medical condition. Is he dead? That phraseology repeated over and over and over again. And when you take into juxtaposition that phraseology, text to Laura Sullivan, found him in the snow at 5 a.m. The unaccounted for time heading in the direction of 34 Fairview Road, 5:18 to 5:35. The repeated questioning of firefighter Whitley, firefighter Woodbury, asking Miss McCabe to look up those things in her phone. She's looking for confirmation, is what she's looking for, when she asks over and over again, is he dead, is he dead, is he dead? You have the testimony that you heard
I'm dead.
from Miss McCabe
I'm dead.
and Miss Roberts. I say them together because as far as these two women were concerned, they did not know each other, really at all. The only time, as they both testified to, that they had ever spent appreciably together prior to January 29, 2022, is when Mr. O'Keefe nicely took them out for sneakers because he had some sort of deal at a Reebok's outlet or something like that to sort of try to pay them back for the help that they provided him and the children. Jennifer with respect to the niece, and Kerry with respect to the nephew. But they're both contacted by the defendant in the early morning of January 29th. As Ms. McCabe testified, John was my friend. I love John, he was an amazing guy. At the waterfall, Mr. Albert said going home to have a drink with his son, Brian Jr., if anyone wants to come. Open invitation to the table. She said to Mr. O'Keefe and the defendant, you guys should come. Both the defendant and the victim indicated that they wanted to come and that they were coming. She describes the phone calls and the text messages that she receives from Mr. O'Keefe that she's providing directions. She indicates she's providing them directions to go down Chapman. She describes how that is. And you've heard this testimony from a couple of different witnesses as far as the steepness as you're going down going down Fairview of coming off of Chapman. That you first go down a big, steep hill. It flattens out for a little bit, and then you go down a second hill. 2 hills going down on Chapman. Matching the GPS native location and the health data as far as where Mr. O'Keefe's phone is, a half mile away from 34 Fairview Road at the time that his health data is reporting that he's ascending or descending 3 flights of stairs. You hear the testimony from Ms. McCabe as far as the last time that she spoke to Mr. O'Keefe. And she's still trying to provide directions to Fairview because Mr. O'Keefe has never been there before and neither has the defendant, which is further corroborated in Trooper Garino's testimony as far as the vehicle passing by Fairview and then coming back in on the other side, having to reverse direction. But she's giving directions and she indicates that she uses a house that Mr. O'Keefe will be familiar with, that belonging to Bella or Bella's mom. Bella's mom is an ex-girlfriend for a short period of time from a long time ago. However, in the defendant's mind, it's so prescient on her mind that she's still talking about it the next morning or later on that morning when she's riding, going towards Fairview Road with Miss Roberts and Miss McCabe in Miss Roberts' car. She's still talking about it at that time. It's that much on her mind. Ms. McCabe indicated that she looked out and she saw the vehicle initially in front of the front door, as did Mr. McCabe, as did Brian Alba Jr., as did Julie Nagel, as did Ryan Nagel, and the vehicle moved up several times or several spots to where it was then positioned. Initially at some point in front of the door, then it moves up further so that it's in the area of the fire hydrant and the flagpole where Mr. O'Keefe's body was discovered later on that morning, at least by Ms. McCabe and Ms. Roberts, and then moves up further beyond that. And I say that in the sense of it moves up further beyond that with sufficient distance for it to then go in reverse for 62.5 feet at 24.2 miles per hour, striking Mr. O'Keefe and leaving him where he was found later on the 29th. Again, the testimony from Ms. McCabe that about 12:40 when she's texting him, she indicated in her testimony she couldn't be certain if Mr. O'Keefe was still out front or had left at that point. She wakes up to a phone call from John's niece Kaylee at 4:53 in the morning. This is from an 8th grader, 14-year-old girl. That's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over again, "Jen, Jen, Jen. John didn't come home, got in a fight, left him at the waterfall." The variations, the different iterations of that story as it evolves and changes over the course of that morning. Ms. McCabe then indicates to the defendant, "We saw you outside of my sister's house." Then she starts yelling, "Jen, Jen, did I hit him? Could I hit him?" Then they start discussing, or the defendant brings up her cracked tail. And then hear her, both Ms. McCabe and Mr. McCabe, hear the defendant screaming outside of their home at about 5 o'clock in the morning, or shortly after 5 o'clock in the morning. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicate, and you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule, pretty strict rule in his house as far as you take your shoes off when you come in the house. And so what did Ms. McCabe and Ms. Roberts both do when they're entering in that house on January 29th? They take off their boots, they get out in the snow, they take off their boots in the mudroom, and then they walk in. What did they both indicate that the defendant did that morning when she came back to the house? Walked right in with the shoes. You hear that second voicemail. It's after the defendants arrived back at One Meadows Ave, after her phone is reconnected with Mr. O'Keefe's Wi-Fi. And you can hear the footsteps. Part of that may be in the garage, part of that might be in the house. Why is it that the defendant has no issue with wearing shoes in the house when Mr. O'Keefe has that strict rule? Because she knows where he is. She knows it's not an issue, he's not coming home, because she hit him with her SUV and she left him in the snow. Ms. Roberts and Ms. McCabe are frantically sort of running around the house looking for Mr. O'Keefe. The defendant's not. They then get in the vehicle. They drive back towards Fairview Road, and again, the defendant from the back seat of the vehicle immediately sees the defendant, starts pulling and kicking on the door, and runs in sort of a beeline straight over to where Mr. O'Keefe is laying on the front lawn. We have the testimony from Ms. Roberts as far as John's phone. John's phone, when the firefighters pick him up, and you recall several witnesses testifying about that, pick him up on the scoop stretcher and they bring him over to the ambulance while they're conducting the resuscitative efforts trying to save Mr. O'Keefe's life. But Ms. Roberts indicated that she observed underneath it, only the phone, but the phone on the grass. On the grass in the area that is completely covered in snow in every other area except under Mr. O'Keefe, which I would submit indicates how long Mr. O'Keefe has been there. Now recall, around 12 o'clock or so is when it starts to snow and it starts to stick a little bit. And you heard all that testimony. And I know it was a lot of testimony about snow, and a lot of testimony about
You think?
weather, but there's a purpose to that. There's a point to that.
You're sure?
As far as the grass underneath Mr. O'Keefe's body, where his cell phone was, Ms. Roberts observed some 6 hours later after it starts snowing, is still visible only under Mr. O'Keefe where his body is, which I would submit as evidence to you as to how long he's been there. Now, on top of that, You also have hours of ring videos of the driveway as far as shoveling and Paul O'Keefe and other people snow blowing and shoveling and all those kinds of things. There's a purpose to that as well. If you look at those, if you look at the video of the defendant crashing into Mr. O'Keefe's vehicle at a speed of anywhere from 0 to 5, which even Dr. Wolf would indicate would not cause the damage to the taillight that was observed in this case. You know what you don't see? You don't see snow move off Mr. O'Keefe's vehicle when they come into contact. You don't see any red or clear plastic pieces in the snow. And if you look at those stills, not the ones that counsel put up there during his closing, but if you look at each of the video in the stills, you can see the damage consistent with the taillight at each and every point. You see the damage consistent with the taillight from the 507 video. You see the damage consistent from the 822 video from Lieutenant Ray from the cruiser camera video when he's pulling into the driveway. You see the damage consistent from the Dighton video at the defendant's home. You see the damage consistent from the right here, February 1st, 2022, when the search warrant is conducted and Ms. Hartnett removes all those pieces from the vehicle. The weather is also important when it comes to the hair. The magic hair, as Mr. Jackson likes to call it. See, the magic hair was actually frozen to the vehicle, as was the glass to the bumper, because the vehicle looked like that on the left when it was caked in snow, when Officer Barrow saw it in the driveway in Dighton as they were wading through 1.5 feet of snow, walking up, because remember, they didn't even pull into the driveway because they had to have someone come down and plow it before they could get into it. That's what the vehicle looked like. What you can see, however, is the damage to the taillight, to the side of that taillight, consistent with it. So that hair, that 7/8 of an inch hair, was frozen to the side. And as you remember, the testimony from Sergeant Buchanan about the heated condition of the Canton Police Department garage, and that's one of the reasons that they took it there, because the other barracks that they could have taken it to didn't have that heated condition. So yes, after it's been in there from January 29th at about 5:30 p.m. until February 1st when they conduct the search warrant, the hair isn't still frozen, as it's contained within a heated garage, and the pieces of glass on the rear bumper have melted. The snow has melted, as you can see from left to right. The weather, also important, I would submit, weather was a weapon. Remember, the cause of death here is not just blunt impact injuries, it's blunt impact injuries and hypothermia. You heard all that medical testimony in relation to it, and you heard all that testimony in relation to the snow and the weather and the wind. Wind gusts up to 37 miles per hour while he's out, Mr. O'Keefe is out there in just a shirt and jeans. Now, you heard also testimony from Ms. Roberts in relation to the injuries she observed to Mr. O'Keefe, that initially on scene, there was one eye that was swollen, not the other. That's indication of the swelling that Dr. Scortibella was testifying to, and no indication of a physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing at the Good Samaritan. Submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony to medical testimony to forensic testimony to the reconstruction testimony. You have the testimony from Ms. McCabe and Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Sarif's cruiser. You have Mr. O'Keefe being covered in snow from the storm. You know where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Sarif. You have the testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer Mullaney has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away, in the darkness, in the snow, in the blizzard conditions. There's no footprints around the body. There's no drag marks around the body. There's no evidence of anything in relation to Brian Albert and Brian Higgins. Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City to go to a funeral for another police officer, for another department, who they didn't even know. Traveled all the way down to New York and then came back before the blizzard, only to come back from that to go out drinking, to come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn? Really? That's the conspiracy? What evidence do you have of that? You have statements that the defendant made to Sergeant Buchanan on January 29th. She was willing to speak but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments and incessant phone calls and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to C.F. McCarthy's around 9 p.m., started drinking vodka sodas, the men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the side, same side as Waterfall. Same testimony that you heard from Ms. Colakithis, observing the defendant going over to her vehicle, getting in the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger seat. She said they were left the Waterfall, were invited to her residence. She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, "I don't know, it happened last night." June 2022, you have that other recording of that other version that she now has evolved into, as far as stating to Sergeant Buchanan, "Are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked." What evidence do you have of that? Mr. O'Keefe never went in the house. You have testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe's phone never went in the house, from the testimony and the data points that you have from Trooper Garino. You know how Mr. O'Keefe was dressed, and you know the defendant knew that. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolakithis, Nicholas Kolakithis, Brian Albert, Nicole Albert, Brian Higgins, all indicated in their testimony, and the defendant knew, based on her questions to the firefighters the next morning, that Mr. O'Keefe was not
Seem to have
dressed
some
for the
options
weather
here
when he left
on
the
YouTube.
waterfall. The weather was a weapon. You have the testimony about the car, the defendant's car being there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan Nagel. You have the testimony of Ryan Nagel, Ricky D'Antonio, and Heather Maxson. Ms. Maxson indicating she saw a male passenger, female operator, as the vehicle was turned. Remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse or 3-point turn on Cedar Crest, is then taking a right onto Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxson are taking a left onto Fairview. Mr. Nagel indicates that Mr. D'Antonio then flashes lights. During that time, Ms. Maxson can see inside the vehicle. She sees a male passenger. She sees a female operator. They follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any damage to the vehicle, or it hasn't happened yet. At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Now, interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. And I asked him, what happened when you open the door? What happens when you open the door to a vehicle? The dome light comes on. So there's a reason I would submit, or the inference that you can make, is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle. And then they're gone. The Nagels, Ryan Nagel, Ricky D'Antonio, and Heather Maxson drive away from that. Here's the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while they're pulling away from the house where everybody's attention is drawn, Ms. McCabe is turned around facing both of them in the backseat. Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 34 Fairview Road. Ms. Levinson is looking back at Ms. Nagel, away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning. You have the testimony, recall, and you have text messages in regard to Colin Albert when he gets picked up from home.
Mr. Lally, 5 minutes.
Yes, sir. Colin Albert, Miss Allison McKay, Brian Albert, Nicole Albert, Caitlin Albert, Brian Jr., all indicating that he was picked up around that time at 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the waterfall in the first place, as far as John O'Keefe and his nephew coming in earlier in the day, getting a couple slices of pizza, what are you doing later on, contained within those text messages. You have the testimony from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic, about those items being recovered. And in particular, the items being recovered on January 29th by that search. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level. 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos in the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found the evidence where it had been, at that same ground level, in the grass, under the snow, at 34 Fairview Road. We heard all of the medical testimony, which I would submit is consistent, from firefighter Formati to Dr. Rice. You heard the testimony regarding the defendant's blood alcohol concentration for Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 9:08 in the morning. You heard it, Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts from C.F. McCarthy's and from the waterfall, and you have the witness testimony in the surveillance video in regard to that. The forensic testimony that you have. In regard to the medical testimony, you have the sort of pattern abrasions, the clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone, at any point in time ever said that Mr. O'Keefe's arm was out like this at the time that he struck and that he did a pirouette and then flew 30 feet in the air. 12 inches of abrasions that the doctors were, the biomechanical people were talking about yesterday, 12 inches and then 6 inches for the tail end, is easily solved by this. And the dimples on his arm are, that I would submit, are consistent with the dimples on the taillight cover piece, are right around this area of the elbow. You have the testimony in regard to forensics as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that taillight housing, on the housing. His DNA is there to the exclusion as well of Sergeant Mechanic and Trooper Proctor. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA, and only Mr. O'Keefe's DNA, is on his clothing and his fingernails, consistent with Dr. Scortibello's testimony that there is no evidence of a fight or an altercation. There's no one else's DNA under his fingernails. There's no one else's DNA on his clothing. You have the testimony from Ms. Hartman and Trooper Paul as regard to the damage that they observed, the dent, the scratches, the 7/8 of an inch hair. You have the testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Valier and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes, Your Honor. All consistent with the pieces of taillight that are found within his clothing. Ms. Gilman, if I could.
What, you're putting up an exhibit with your 1 minute?
This is what this vehicle looks like backing up at that speed for approximately that distance. There's another, years and years ago.
Do you know how long a minute is, sir?
In Norfolk County, in Braintree, what is now Quincy, eventually became a far smarter man than myself. Eventually became president of the United States. His name was John Adams.
What?
John Adams once wrote, "Facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What the constellation of the facts and the evidence ineluctably demonstrate here was that the defendant drove her vehicle in reverse for 24.2 miles
Say
per
it.
hour.
Say it.
62 and a half.
Say it, Judge.
Struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you. You've gone over.
Thank you, God.
I literally have one sentence.
One sentence I'll give you.
From that facts and that evidence, I would submit ineluctably demonstrates her guilt on each of the indictments before you, and I would ask that you find it so. Thank you.
All right. All right. Thank you. Jurors,
Okay. All right. Before we move on to the jury instructions or whatever else is that they're about to do, first of all, it is true. It has come to an end. So that is great. There was much rejoicing. Yay. Okay. All right. So I'm going to start with some praise, and then I'm going to start with some critique, and then I'll end with some critique. Okay. In the praise column for his close, it was substantially better organized than his opening, which was a complete jumbled nightmare of just facts without any particular connecting threads, without any story, and with no particular flow, so that you had no clue where he was going to go next at any different time. It was a disjumbled, unorganized, conflated nightmare of facts with way too much detail and absolutely no story. That was the opening. For the most part, up until last, 15 minutes or so, it was substantially better organized. It had better flow. Not good, just better. It was better organized. It was a more coherent narrative. I almost said story, but then I stopped myself because no. But it was a more coherent narrative. And it was a better presentation in a more organized way than the opening. Also, he started fairly strong with the I hit him. That was pretty good. Probably should have ended there too, but whatever. Okay, so it was substantially more well organized and well presented. It was a good example of what to do when you don't have a lot to work with, because he doesn't have as much to work with as the defense does. So he took the shambles of his case and managed to put them together in a way that was for the most part, coherently structured presentation. Not so much in the last 15 minutes, but the first 45 minutes. That being said, however, it was droning and boring, and it was mind-numbingly presented. So it was so hard for me to listen for the technical detail, because he was making it impossible for me to pay attention. I think I was fading in and out of consciousness at various points. It was so drony, so monotone. It has no stage presence whatsoever. This man could use some sort of acting class or public speaking class or something. I don't know. But what I do know is it was mind-numbingly boring. And it was very, very difficult to retain any data. It was very difficult for it to lodge in your mind, because it was just a constant drone of mediocrity in terms of stage presence and speechcraft, which is not different than we've seen up to this point. That has been Lawley's trademark from his opening, through his questions, from his cross, and into the close. It is his defining characteristic is he has a very monotone affect, and he doesn't help you with changing speed, vocal variety, intonation, or any sort of other speechcraft tools that would help you understand or comprehend or retain anything he's saying. Also, his case is still absolutely bullshit, right? All I said was earlier that he did a good job of taking the shambles of his case and mostly putting it together in some sort of organized fashion that was at least an improvement on the opening, where it was total disaster. So it was an improvement. But, it's still a complete shambles of a case. Really, all he has is, I hit him. That's really all he has. And everything else is some bullshit. And so that is my overall conclusion. But, to be fair, if there is a juror out there who likes the way that Lally speaks, and they're looking for reasons to convict, and, they're being dumbs because they're not applying the relevant legal standards, then I suppose Lally gave them something that they could hook their teeth onto, however bullshit it is. But, whatever. So, yeah. I also appreciated that he took the time to say that Proctor's statements were reprehensible, and so dealt with that elephant in the room, and I thought in a fairly effective way. Well, effective technically, not so much in terms of presentation, but whatever. So yeah, it was yeah. And I would also disagree sharply with much of the characterization of the evidence that he presented. So there's that. So yeah, I know the judge is giving jury instructions. I'm giving my thoughts. We'll get there. Don't worry about it. And so that's what I would think. We saw basically a master class presentation from the defense lawyer and not so much from the prosecutor. So yeah. So now we will listen to the judge's jury instructions and the charge of the jury, and we will do that now. Okay, let's press on.
I have my instructions on the law. I'm going to give you. My guess is it's probably about an hour.
Oh dear.
Start it now, but does anybody need a short break? We can take a short break. Okay, we'll come back in 5 minutes.
Leaving your notebooks under your chairs. All rise, jury out.
You are.
All right, we can skip the break.
To make sure that I give you the instructions accurately, I will read them to you.
Good.
You will also get a written copy. I'll probably send in 3 or 4 to the jury so that you can refer to it in the jury room during your deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud.
Really?
You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part 1 of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution is proved beyond a reasonable doubt through evidence presented during the trial that Ms. Reed committed the crimes charged. I will explain reasonable doubt in just a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Reed does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. The burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defense be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, how do you decide whether the Commonwealth has proven each element of an indictment is true beyond a reasonable doubt? Let's talk first about the roles we all have. You folks are the most important people in the courtroom. It all begins and ends with your function. You will determine the facts in this case, and that is your job and your job alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must determine the facts solely and entirely on the evidence as you have heard it and seen it in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion or sympathy, passion or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged, or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on the evaluation of the evidence. Now, the arguments of the lawyers are not evidence. They are not witnesses. If a lawyer, during argument, made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They are simply doing their job during a trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. Now, the verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits in the case. There are some things you have heard about that have not been introduced into evidence, such as written statements by witnesses, police reports, autopsy, and accident reconstruction reports. Occasionally during the trial, you have heard references to such documents, and you may naturally wonder why neither side introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you view exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Any information that you may have read, heard, or seen about this case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to questions, and the exhibits are evidence. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in this courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law to that evidence. I have allowed you to take notes during the trial, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with other jurors. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then. You'll remember that we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship do they have to the case or to the other witnesses or the parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witness and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for that purpose. Now, you've heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions.
Whoa, whoa, whoa. I didn't think the judge was going to give this instruction. She said yesterday she wasn't going to give this instruction, and now she's giving the instruction. Wow. I guess she changed her mind. Wow. Okay. Fine. Cool. All right.
First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted test or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Now, during the trial, I gave you some limit.
That's a big win for the defense there. That's a big win for the defense getting that instruction. So that's at the discretion of the judge to basically give that instruction she just gave about the police may not have followed procedure and you may consider it. And she said yesterday she wasn't going to give that instruction. The defense requested it and she said she wasn't going to give it. And that's a fairly notable win for the defense to get that instruction, because the judge, the lawyers were always free to argue it. Like the investigation sucks and you should consider it, but actually get the instruction from the judge, that's a big win. So good, big win for the defense. Surprising, very surprising, because the judge says she wouldn't give the instruction and she just gave the instruction. Wow, big win.
Instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I am going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You have heard evidence about interactions that Ms. Reed had with Mr. O'Keefe and other witnesses in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29th, 2022. You may not consider that evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must also have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored them were, in fact, John O'Keefe, the defendant, or the witnesses who testified about their communication with John O'Keefe and or the defendant. If you do not find it is more likely true than not that John O'Keefe, Karen Reed, or the witnesses who testified here before you were the persons who authored or transmitted the electronic communications, then you may not consider the electronic communications in deciding the case. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You've heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's cell phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that the defendant was aware of John O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you reasonably can infer from the evidence that she did learn of it. You've also heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence that you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witness testimony that I mentioned earlier, including any bias or motive these opinion witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of these witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the assumed facts are true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. Now, you have the same powers with respect to the exhibits that you have and the testimony of the witnesses. Look them over and decide the weight, that is the value they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it is written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what the exhibit purports to show and how much weight, if any, you give each exhibit. Now, you've heard me talk about the sources of evidence in this case. Those are the tools that we have to decide the case. Now, with the evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe, because you are entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seems more reasonable to you. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household, a child, roommate, or spouse, hands you the mail and states that he or she observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the event with his or her own senses and told you what he or she observed. The issue you would have to decide is whether the witness is credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case, not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I have just described. You may have noticed that the defendant did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that the defendant did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. All right, that completes my first part of the instructions.
Okay. And it also sounds like, therefore, that she's not giving the consciousness of guilt instruction, which the state asked for. She said she'd think about it. I was like, she's going to give it, and she didn't give it. It doesn't sound like it, right? You think it would be there. So it sounds like a double one for the defense. So the state had argued that, there was ability, inferences could be drawn, that Karen Reed deleted the Ring videos and other things that she did was showing consciousness of guilt. It's like, no, I don't think so. And the judge did not give that instruction about, the defendant did things and consciousness of guilt. And she gave the instruction that you can use the shoddy testimony or the shoddy investigation against the police. So The defense sounds like it's winning all the the defense sounds like it's winning everything. I'm not sure what changed since yesterday, but damn, that's like the defense seems to have won since yesterday afternoon. So, okay.
Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Ms. Reed is charged with second-degree murder. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then, you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of those elements beyond a reasonable doubt, you must return a verdict of not guilty. The next is manslaughter while operating a motor vehicle under the influence of liquor. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and/or the percent of alcohol in the defendant's blood was a .08 or greater. You'll have both these choices on the verdict slip. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. And fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the well-known things that drivers do as they travel on a street or highway, and also in doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which, alone or in sequence, will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and/or the percent of alcohol in the defendant's blood was a .08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient itself to prove that the defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip and you should decide each one. The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was a .08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test. Mr. Court Officer, I know it's traditional to not allow anybody in and out of the courtroom while I'm charging, so I'm going to ask you to follow that at this point. Thank you. It's distracting, and I don't want it to be distracting for you folks, okay? The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved the element. Here, the defendant must have intended her acts in the sense that they were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition and how well the defendant could see and could control the vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what was the time of day, the weather and the condition on the road were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you shall return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor.
I thought we weren't doing lesser includeds. We're doing lesser includeds now? I'm confused.
So I will define involuntary manslaughter. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless. I will now discuss each element in more detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or with disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined them. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and negligence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove.
Again, we're doing lesser includeds. I mean, you guys were there with me, right? When they were asking yesterday. I thought the state said they didn't want to do lesser includeds. And now they're doing lesser includeds? Did the state change its mind since yesterday? I am so confused right now. Yeah, I don't even know what's being charged at this point. I'm confused. Okay.
The greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that could have avoided, that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The next indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further. Save a little time for you. Right? As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. Now that completes the second part of my instructions. I will now.
Okay. And now we're going on to part 3. Part 2 is a lot. It's like I really need this in writing so that I can break it down, because there's a lot there to break down, and then I can go look at the associated things. But I don't assume that the written instructions are available yet. They're probably not even on the docket yet because they're just being read yet. So hopefully we can get a copy and break them down, because it's a lot to talk about.
I'll turn to the final instructions. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are still 14 of you. To avoid the need for a new trial, if one or more jurors becomes ill or has to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. However, when you begin your deliberations, the law of Massachusetts is that there can only be 12 jurors. Therefore, at the conclusions of my instruction, the clerk will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted, because, as I've indicated, it is important that we have extra jurors in the case of emergency. If we did not impanel extra jurors and a juror became ill or for some other reason had to be excused, we would have to try the case all over again with a new jury.
Exciting that
In the
prospect
event
that
that a
is.
juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start their deliberations all over again from the very beginning. Therefore, it is important that the alternates not discuss the case with anyone, including each other, for if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not influenced by anyone else. Now, different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own foreperson. In Massachusetts, the judge is responsible for selecting a foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations, however, in that sense is exactly equal with all the jurors. I am going to ask juror in seat number 1, juror number 400. Would you be our foreperson, please, sir? Thank you.
That implies that he's going to be part of the jury, but you haven't selected who the alternates are yet. So isn't it a little premature? I'm just saying, if you haven't selected the alternates, how do you know he's going to be on the jury? Okay, fine.
When you return to the jury room to deliberate, the court...
See, apparently, the judge also has problems with logical reasoning. Well, I hope you get lucky. 2 out of 14, 1 out of 7 chance. Okay,
Officers will deliver to you all of the exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge. You should not begin deliberating until all 12 jurors are together in the jury room, and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong, but no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of returning a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin conducting an immediate straw vote. Rather, I encourage you not to take any votes until you have completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not consciously aware of them, and I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing, and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as a member of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer. Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. I'm going to seek counsel before we reduce your number to 12.
Okay, that was a lot on so many different levels. Beep, beep, beep. Beep, beep, beep. More beeping. Beeping noises continue. I need a copy of those to break it down because I have some questions. I need to know exactly what's being charged so I can break it down. Well, you want to bet the 2 reduced will be the attorneys? Yeah, I feel that. I feel that. Oh, Lord. How y'all doing out there in uncivil law land? Y'all having fun? You having a good time with your friend, Uncivil Law? We're all enjoying each other, having a good time. I'd like to once again pimp my merch store. You can follow the link above for my merch store. We got some cool merch, cool Karen Reed stuff, and some other stuff. You can see Callie the Beef Fish welcomes you. We got a mouse pads. We got an evidence cup sticker. We've got an evidence cup made of glass. We got the limited edition Canton CSI holographic sticker with a picture of paper bag and solo cup on it because, of course, it does. You know you want it. We have some nice learning from the misfortune of others shirts and mugs. We got some Uncivil Law mugs and travel mugs, legal education with an edge, all kinds of good stuff. So please check out the merch store. Check some fun stuff today. All right.
You are unmuted.
All right, so Mr. Clerk, will you choose the alternates, please?
Could the juror sitting in seat number 3, who is juror 79, step down and take your place as an alternate? And the juror sitting in seat number 2, juror 14.
All right, you got lucky. You didn't get your number 1.
All right, so ladies and gentlemen, we need to swear in the court officers. They're going to be in charge of you during your deliberations. I suggest that you listen to the oath that they are taking so that you can be aware of their responsibilities. Now you can swear them, Mr. Clerk.
You swear that you will keep this jury and alternates in some separate but convenient place until they agree, that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they are agreed, nor suffer them to disperse until they're discharged of their verdict, except by further order of the court, so help you God. Thank you.
All right, so jurors, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you have heard here in the court during trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may now retire and deliberate your verdict.
Jurors, this time taking your notebooks. All rise, follow me.
All right, people. We'll watch this as the court disperses. And then we'll have a little bit of commentary and see whether or not we can track down a copy of these instructions would be nice. We may not be able to get those right away. Or at least a listing of all the charges would be nice. Presumably, someone might be live tweeting this. That'd be actually helpful. You know what you could do? You know what you could do to help me out would be to see if someone's live tweeting it and maybe has a listing of all the charges or
I'll give you a few
something.
minutes to work with Mr. McDermott on the verdict slip. And then
That'd be helpful. Thanks, Kestrel. I'd appreciate it.
Thank you, Your Honor.
Yeah. One of the news sites or someone tweeting it might have a listing. And then we can try to break it down about exactly what's charged. We went from 3 charges to decidedly more than that. So unclear at this time. All right. No, it will be written. She just said if there's a conflict that they're supposed to go with the oral over the written, which doesn't make sense, incidentally, because the written is more well prepped, that the oral would overtake the written. But that's what she said. So it is in writing. I know it's in writing. It's just that if there's a conflict, we're supposed to follow the oral. If anyone can remember exactly what she said. But good luck. Yeah. So do I think they'll come back today? I think they should. But now that they have all these alternates, now that they have all these charges, these lesser includeds, who knows? But I mean, they all require her to have committed the killing. So they're all just different versions of murder, essentially. Or all different versions of homicide, I suppose, more properly. No, homicide is a medical determination. Let's go with all different versions of murder. That's slightly more accurate. I guess. But yeah, they're all different versions of murder in their combined form. If I got it right and I was listening as best as I could, but it was murder in the second degree, vehicular homicide, DUI, then just vehicular homicide, then just involuntary homicide, I think. And there might have been something else in there. I don't know if anyone heard anything else, but that's what I kind of heard. And we'll see. Yeah. And of course, the leaving the scene of the accident as well. So I think those are the charges that are on the table, but it'd be nice to have a firm list. And then we can break it down in the instructions and we can go through it step by step, plus look up their assorted penalties so that we can try to flee that. Yeah. So I think that's, yeah. And all those homicide charges would merge because she can only be guilty of it once. So they would all merge into, I think, the most severe version of it. I would imagine, because I don't think you can commit the same murder more than once. So they would be concurrent sentences, I would imagine, because they are all the same fundamental thing. Yeah. The funder not guilty of exchanging insurance information. That's true. She didn't leave the insurance information with John O'Keefe's body, I guess. Yeah, homicide is ending by another human. Yes, but homicide is a medical determination, as opposed to murder being the legal determination. So it's like, okay, what is more accurate here? Because technically, a homicide doesn't necessarily have to be criminal, right? A self-defense is technically a homicide. And it could be something else that's not criminal. That's somehow, it could be pure accident, right? I mean, at least hypothetically. So I'm like, okay, what is more accurate? To say they're all versions of homicide, or are they all versions of murder? I'm like, well, since murder's the legal determination, I'll go with all versions of murder. It's like, as I pick between these twin universes of which is the more accurate description. So I went with murder, because homicide is not a legal determination. So that was the delineation there. Oh, no worries. You're fine. That's fine. No worries. You guys are fine. Actually, as long as we're here and we have a little bit of time to kill while hopefully my mod is finding the information or something, as long as we have some time to kill, I would appreciate your feedback on this issue. Because I was, for example, I was reading some of the comments on the Nick Ricada stream that I did recently, where I was doing a live reaction to the cocaine apparently found in his child's. Why does it sound weird? No, child's. That's the right verb. The cocaine apparently found in his child's hair. Yeah, that's right. So I was reading the comments, and there were a fair number of comments, including in the live chat, basically saying you shouldn't deal with trolls and you shouldn't respond to people questioning you. And it's always a little bit difficult for me to figure out, and I don't know there's really a fundamentally good answer to this, but it's how do you know what's real? How do you know what's a real comment? How do you know what's trolling? How do you know what to respond to and what not to respond to? And, and to what degree, if at all, should you try to defend yourself from what you believe are scurrilous accusations, are all very interesting questions for a streamer. So I'm not sure there's a great answer, but whatever. Yeah, so I don't know the answer to that question. Also, I don't want to throw a good faith questioner under the bus, because it's like, it's probably helpful to assume good faith as a general proposition. And there's definitely been times where I've gotten really mad at the chat or like yelled at the chat, and people don't like it when I do that either. So people don't like it when I yell at the chat or berate the chat, and people don't like it apparently when I patiently explain to the chat either. So it's like, I don't know how to, I guess you can just ignore it. But then the question is, what do you ignore and what do you respond to? So I don't know if there's a great answer to that question, but yeah, whatever. Yeah. Oh, and also a point of clarification, because I did see in the comments where someone, and it was my fault, I misspoke, but they misunderstood what I meant. Like I had talked in the stream repeatedly about how the chat was resetting on my side. I was streaming through Melon, which is a StreamYard competitor. I almost never use it. And for some reason I decided to use it. And apparently that was a mistake. But whatever. I was streaming through Melon and its chat interface kept like resetting on me. So I couldn't like read the YouTube chat. Like right now I'm just looking at YouTube on the back end. So I have it native. But on that chat, I was just reading it in StreamYard and it kept like resetting. And so I couldn't tell like where I was or what I was reading. And at one point I said, oh, I'm tired of the chat. Like at the end, I said, I'm tired of the chat. So I'm going to go read super chats. And, you know, there was a comment, well, if you're tired of chat, maybe you should just stop streaming. And it's like, oh, I misspoke. Because I didn't mean I was tired of the comments. I just meant I was tired of the chat always resetting. But in that moment, I didn't express myself properly. So, you know, hey, what can you do? Yeah. So just little things you observe, little things you think. But I do feel a little bit of a need to defend myself sometimes. That's true. Which I think is a fairly natural reaction. It's just perhaps weird when you're a streamer because there will always be negativity. And so if you're always responding to the negativity, you'll never get anything done. So it's probably better to just ignore it and just be like, just take the praise and adulation. But something that's harder, I guess. I do love you guys. Generally speaking, there are a couple trolls out there and they know who they are, or they should know who they are. But generally speaking, I love 99% of you. 99% of you are great. The remaining 1% might be bastards, but that's all right. Peter ignores everything. Yeah, he basically does. That's fair. And to the extent he does address it, he does it in a very summary way. So, yeah. And his channel's growing like crazy. So maybe the Peter model's the way to go. Although Peter may be more handsome than me. It's sad, but potentially true. So what can you do? What part of the world am I located? Well, as the friendly sign behind me shows, I'm located in Texas. So yeah. $140,000 people think I'm pretty great. That's true. That's a fair point. Thank you. Yeah. I will note, of course, that Lawyer You Know was getting a lot more people in his lives than I do. So he's doing something right, and he's getting a lot more super chats than I do. So he's doing something right. So when people are getting way more people in lives than you, and they're getting way more super chats than you, it's like, well, they're doing something right to gain an audience and keep it. So worthy of note. Who's Peter? Lawyer You Know. His name's Peter. It's not a competition. It's a little bit of a competition. Not to put too fine a point on it, but I'd rather get those super chat dollars than Peter gets them. So yeah, it's a little bit of a competition. A little bit. What do I think of Massachusetts residents after seeing this trial? I don't really think anything globally. I think that Massachusetts residents are probably, broadly speaking, the same as residents anywhere in our great nation, which is both an encouragement and an indictment, I guess. But I think we've seen enough shenanigans from other trials to know that this, unfortunately, is not indicative of anything other than this is just the way that some police departments are. This is the way that some police officers are. This is the way some people are. So I don't really have any particular opinion of the people of Massachusetts. I think they're broadly speaking the same as anyone else. You're too cheap to join? I mean, it is literally 99 cents a month. I do make it pretty cheap to join. I mean, I know everyone doesn't necessarily have 99 cents, but I've made it literally as cheap as I can so that everyone can join because, you know, it's $1. But if you don't have $1 a month, I understand. Some people need to watch their budgets more. I get it. It's fine. The fact that you're here and participating in chat means a lot to me too. That keeps me going. So I appreciate that too. Your time and energy and participation means something to me too. It's very helpful. Lolly reminded you of the Rittenhouse prosecutors. I'll disagree. The Rittenhouse prosecutions were leagues above Lally. They were better in their presentation. They were just bringing some bullshit. Kestrel appears to have found what I need. Ho ho ho! Do I have what I need? I might have what I need. Sort of. I have. Okay, this didn't print well, Kestrel. Can you possibly? Yeah, take a look at the PDF that you sent me. It doesn't really have the text that I need. So could you check that out and make sure to send it to me again, and then we'll discuss it. That'd be awesome. Thank you, Kestrel, for trying to find it. You're awesome. $49.99 from Truth Streaker. That's a very generous super chat. Thank you very much for the thing. Joe Neerman. Apparently it's his birthday today. Happy birthday, Joe. Just got a text from him. Let me read this real fast. Okay. Yeah, okay. I should be able to do that. I can do it. It's happy birthday. Happy birthday, good logic. Cool. Excellent. Thank you very much. All right. Let's see if this is what I need. Okay. Commonwealth instructions. Okay, cool. Thank you very much, Kestrel. Oh, this is the Commonwealth's request for jury instructions, which we can use because at least it will give us the charges, I presume, which will be enough for our purposes. Is this correct? What is this dated? This is dated from June 14th, so this should be correct. Second degree murder. Okay, this looks correct. All right, we'll go with this. Thank you, Kestrel. Can I print this? Can I? Well, I should be a member of Scribd. Come on. I don't want to download anything. No, you're great. This is a good place to start. So give me a second and we'll put it on screen. This is so annoying, the way that it's doing this to me. That's all right. We'll do it the hard way. You and me will not be deterred. We will not be dissuaded. All right, let me take out the long crime feed because we don't need it. Okay, I don't need that feed, and I do need another window. All right, so this will give us a good place to start for the charges. Can you pay annually? No, unfortunately not. There's no way to pay annually through the services that we're using. Yeah, you posted the PDF. You did great. Oh, is it just the naked PDF? Oh, it is naked PDF. Oh, that's even better. Thank you, Kestrel. Kestrel's kicks ass. Thank you, Kestrel. Everyone say thank you, Kestrel. She's doing a great job. Let's see, window capture. Okay, let's do this. All right, great. All right, now I can reduce this. And I can do this, and I can make this bigger. And I can put my face on screen so that you can see my smile. Great. And I can put the little Uncivil logo on screen. Also great. Fantastic. All right, so this will give us, this is the Commonwealth's request for instructions, which is good enough as far as going through the elements of the charges, so we can discuss this. All right, so Karen Reed is charged with second-degree murder, manslaughter while operating a motor vehicle under the influence of liquor. $10 from Jonathan Algar says, I think Lally set a pretty low bar for a closing argument. What would you have done differently if you were to close for the Commonwealth? Well, for starters, use a little bit of vocal variety, change of pace, intonation, and a little bit of energy would have gone a long way. That would have been helpful. You know, just a little bit of stagecraft would have been a really good start. And thank you for the super chat. All right, so we're charging her with second-degree murder, manslaughter while operating a motor vehicle under the influence of liquor, so manslaughter DUI, and leaving the scene of an accident. All right, so now here are the instructions. Okay, fine. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following. The defendant caused the death of John O'Keefe. Yeah. The defendant, one of these things. All right. Intended to kill John O'Keefe. That is, it was my goal. It was my purpose. I was trying to kill him. That was what I was trying to do, right? Intended to kill. Intended to cause grievous bodily harm. Severe bodily injury. Typically, we would define this as like a quasi-permanent injury, like a broken bone or a severe, as opposed to just a simple assault, right? So this would be, that's sort of the line, is a grievous bodily harm. So one of those things, or intended to do an act which, under circumstances known to the defendant, a reasonable person would have known, create a plain and strong likelihood that death would result. So this is knowing, right? So this is intent, and knowing. So if we go through our model penal code, for those of you who don't know the model penal code, intent comes in 4 different flavors, or mens rea comes in 4 different flavors, I suppose I suppose 5 if we want to go that way. But mens rea, mental state, comes in 5 flavors. All right, strict liability, which is almost never used in criminal law. So you just did the thing and there's no mental state. Okay, that would be 1. All right, next up the chart is negligence, simple negligence. What is simple negligence? You have a duty, you breach the duty, harm resulted, right? And there's causation. So you have a duty, you breach the duty, the duty caused a harm, and there was harm. Okay, that's a simple negligence. What would be a good practical example of negligence? Your everyday normal automobile accident is standard negligence, is a good example, right? You have a duty to drive a car safely and not hit others. You were distracted and not paying attention. You hit a car. You weren't supposed to do that. You caused harm. You dented the car. You caused injury, right? So your every normal day-to-day accident is negligence. It doesn't mean that you had any maliciousness in your heart. It doesn't mean that you had any desire in your heart. You just didn't pay attention, and you had a duty to pay attention. So that's simple negligence, right? That's next up the list. All right. Next after negligence, recklessness. Okay. This is a knowing disregard of a conscious risk. So in recklessness, you know the danger exists, but you don't care. Okay. Classic example, drunk driving is classic recklessness, right? Everyone knows that driving under the influence is really bad. You are consciously disregarding this risk by driving drunk, right? Everyone knows this risk exists. You know the risk exists. You're doing it anyway, right? You're consciously disregarding the risk. So that's standard recklessness, right? It is the apprehension of a problem, and I'm doing it anyway with apprehension of the problem. But it's a more broad thing, right? It's not that I know a specific thing is going to happen. Right? So the difference between recklessness and knowing, which we'll discuss in a second, is recklessness, you don't know what's going to happen. You just know you're disregarding the risk. So the knowledge is in disregarding the risk. All right. So next up the chain is knowing. In knowing, you know the thing that's going to happen. Okay. You know this result is going to occur, or you like strongly suspect it, right? So we've moved from I'm driving a car drunk and bad things are likely to happen versus I have awareness of a specific thing and I'm now in disregard and I'm doing it anyway with knowledge of the specific thing, right? That's knowledge. And then the next up the chain where we end the chain is intent or purpose. So intent or purpose. I want this result to occur. I'm no longer disregarding a general thing. I'm no longer disregarding a specific thing. I am trying to accomplish this. This is my goal. I'm trying to do the thing. This is as guilty as it gets, right? So that is your 4 stages, or 5 if we count strict liability. Strict liability, which we almost never use. Negligence, which doesn't really go in most criminal law. So, strict liability, negligence. Negligence is much more typical civil standard. Standard automobile accident is just civil. Negligence not used in criminal law very much at all, except in very specific circumstances. Then we go to recklessness, then we go to knowing, and then finally purpose or intent. Those are our hierarchy of mental states. Okay. All right. So now with all that background in mind, we can reread this. And you can understand exactly what they're saying legally, right? Intent to kill John O'Keefe. Okay, so we're at the top of the pyramid. We're using the word intent. Intent to do what? Kill. Meaning what? It is my goal that he dies. Pretty easy, right? All right, intent to cause grievous bodily harm. Okay, what do I want to do? I want to cause him grievous bodily harm. What is grievous bodily harm? A serious injury. For example, a broken bone. Or other serious, I hit him with a beer bottle or something, I clubbed him or something, as opposed to just a simple assault, right? I punch you in your arm versus, I punch you, in your face maybe. Something like that, potentially, is where we're trying to split the line, okay? And then we talk about intent to do the act. So I intend to do the act in circumstances known to the defendant. So now this is more knowledge, right? So I still intend to do the act in knowing disregard. So this is knowledge. In circumstances known to the defendant, so the defendant has to know they exist. They have to know that circumstance exists, the knowing disregard. A reasonable person would have known, knowledge, creates a plain and strong likelihood of death. So in this case, I'm choosing to disregard a known circumstance that would lead to death, okay? And so that is basically intent or knowing murder. All right. So that's what they say. Okay. So now the court says, I'll discuss these requirements in more detail. The first element is the defendant caused the death of John O'Keefe. A defendant's act is a cause where the act in natural and continuous sequence results in death, and without the death would not have occurred. So we have but-for causation. But-for causation is the second part of that. Without it, it would not have occurred. But for it. But for me doing it, he would be alive. And then also we have proximate cause in a natural and continuous sequence, right? There's a proximate cause. So this was a foreseeable chain of events, right? Okay, so that makes sense. Easy enough. The second element is the intent to kill, the intent to cause grievous bodily harm, or the intent to do the act which caused the reasonable person to know there's a problem. All right. So the court says there are 3 prongs. The first prong is the defendant intended to kill. Self-explanatory. The second prong is defendant intended to cause grievous bodily harm. Grievous bodily harm means severe injury. I think that's not quite, I think I would be a little bit more careful in defining it that way. I don't think severe injury really captures adequately what grievous bodily harm means. I would prefer a little bit more verbiage, but okay, fine. The third prong is the defendant intended to do the act which circumstances known a reasonable person would know creates the risk. Let me understand how to analyze it. You must first determine whether the defendant intended to perform the act. So they must do the act on purpose, what it is, right? It's not an accident. They're trying to do the thing, whatever the thing is. If you find that they intend to do the act, you must determine whether the defendant herself actually knew about the circumstance. So if she intended to do the act, but she didn't know about the circumstance, it doesn't count, right? Then you must determine under whether circumstances known a reasonable person would have known the act would create a plain and strong likelihood. So we're trying to distinguish between, yes, well, I'm aware of it, but a reasonable person wouldn't think death would ensue, right? So we're trying to cover our bases here. They did the thing. They knew that they knew that, you know, that they knew about the circumstance, and a reasonable person would know that it would lead to death or would be a strong likelihood of a death. So, you know, there you go. All right. So an example, might be something like, I don't know, shooting into a crowd, maybe, right? So I'm just shooting a bullet into a crowd. It's like, am I aware the crowd exists? Yes. Am I aware that, you know, that creates a plain and strong likelihood of death? Yes. So we're distinguishing here potentially between shooting a person in a crowd versus shooting into the crowd, right? If I shoot a person in the crowd, then I'm intending to shoot the person, versus I'm intending to shoot into a crowd. Well, at this point, I'm no longer intending to shoot any particular person. Am I still guilty of murder? Yes. Because, well, I did a thing aware that the crowd existed, and a reasonable person would know shooting into a crowd might cause someone to die. So that would be an example to try to break it out, the distinguishment. All right. If you have reasonable doubt as to whether the death was accidental because it was caused by negligent, careless, or mistaken act, or resulted from cause separate, you may not find intent. That's pretty easy, right? If it's an accident, it's none of the things I mentioned. If it's negligent, it's negligence. If it's careless, it's careless. If it's mistake, then it's not intent. Mistake of fact here, by the way, not mistake of law, mistake of fact. You know, so that would be, you know, a valid thing if they were mistaken because they're no longer aware of it, right? If the Commonwealth proves both elements, you should return a verdict of guilty. Okay, so prove those things. That makes sense. Easy enough. Any questions so far? We'll take questions about murder in the second degree as we just went over, but do you have any questions before I read on? I'll just give you a second to type if you have a comment or question. Testing 2741. DA only argued intentional. Can convict of negligence? No. Not of negligence. No. So if I can clarify that question any further, then let me know. Crystal clear? Yeah, see your super chat? Yeah. They never argued accident. I don't get it. Yeah, but their accident is not enough. That's what it just says. So we can reread it because perhaps I didn't say it properly. So it says, if you have reasonable doubt as to whether the victim's death was accidental because the death was caused by negligence, carelessness, or mistaken act, or resulted from a separate clause, you may not find they've proved intent. So if it's accidental, it is not intent. If it is negligent, it is not intent. Yeah. Doesn't all this stop if they decide that she wasn't killed by the vehicle at all? Yes, it does. Because that would mean that she didn't kill him. So yes, if John O'Keefe was not hit by the vehicle, then yes, that would stop it necessarily. Does the murder number degree go up or down? In relation to what? This is second degree murder. I don't understand your question. You really don't understand how they argued manslaughter because it's a lesser included, as we're going to discuss in a second. To the extent it is, because manslaughter just simply is murder minus things. So it changes the intent element is what makes it manslaughter. So to argue murder implicitly is to argue manslaughter, because it has to be manslaughter in order for it to be murder, but not the other way around. Because every murder is necessarily a manslaughter because it's lesser included. It just is fewer things. And murder just adds more things to make it murder. So if it's murder, it must be manslaughter. but not the other way around. So that's why the lesser included makes sense. All right, let's go ahead and continue on. If she just bumped him with the car but killed him, it could be manslaughter. That's possible, but we haven't gotten to the manslaughter charge, so I'll let you know if it's possible. But we haven't gotten that far yet, so we'll let you know. All right, so any further questions about the murder charge legally? I'm not seeing any further comments, so we'll press on. All right. Manslaughter while operating a motor vehicle under the influence of liquor. Okay, so this is a separate charge now. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following. First, the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right to access. Purely private does not count. Third, that while the defendant was operating the motor vehicle, she was under the influence of the intoxicating liquor and or the percent of alcohol was 0.08 or greater. So if it's 0.08 or greater, then as a matter of law, you're there. If it's not 0.08 or greater, you can still find it, which is, again, not unheard of legally. And this is true. This is true of most DUI charges in most states, technically speaking. It might be called something different, incidentally, in your state. But technically speaking, in most states, just because you don't blow the limit doesn't mean that you can't be found guilty of DUI. Now, obviously, it's harder because if you blow the limit, then you've blown the limit. And so you're just there, right? As opposed to, I haven't blown the limit, but I have to show something else. So it's at least hypothetically possible to convict of DUI in most jurisdictions, even if you're below the limit. But of course, it's harder. So it usually doesn't come up. In some states, yes. In some states, no, but that's not unheard of. Okay? All right. So if she was under the influence or 0.08, either one will be fine. Fourth, the defendant operated the vehicle wantonly or recklessly. Wantonly just means devil may care, which basically means recklessly, right? It just means without care or attention, so as to create a high degree of likelihood that substantial harm would occur, which, you know, if you're intoxicated, you're kind of there, to be honest. But I suppose, strictly speaking, if you somehow manage to drive it perfectly safely, then, you know, okay, fair enough. And fifth, that by such operation, the defendant caused the death. That makes sense, right? To prove the first element, the Commonwealth must prove beyond a reasonable doubt the defendant was operating a motor vehicle. Operating means operating. You know exactly what it means. We don't have to define it further. To prove a second element, the Commonwealth must prove by reasonable doubt the defendant operated the motor vehicle on a public way. Any street or highway that's open to the public is public. So fair enough. Okay. To prove the third element, the Commonwealth must prove that while operating the motor vehicle, the defendant was under the influence of intoxicating liquor. All right. So now they have to define what under the influence means. It's not legal to drive after consuming alcohol as long as the operator is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person's under the influence of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly, which arguably is probably any amount of alcohol, but I digress. Did they do a BAC test? No. I think they did some lab test, but it wasn't certified. So, which, you know, leads to its own set of problems. So I think they did some sort of test, but it was not certified. Because, you know, well, why would it be certified? Because that's just how well the government's doing their own case. The amount of alcohol necessarily to do this may vary from person to person. The Commonwealth is not required to prove the defendant actually drove in an unsafe manner, but is required to prove their ability was diminished. You may rely on your common sense. So basically, did you kill somebody while driving drunk? That's a separate charge. Sounds circular? Well, it's not exactly so circular so much as definitional. And hopefully they sound the same because, that's kind of the goal. So I don't know about that. Yeah. Test was inadmissible. Yeah. So just another failure by the Commonwealth, another day, another failure. What else to prove? So fair enough. We don't really have to dwell on that anymore. You guys understand what's going on. Okay, now we have the lesser included of involuntary manslaughter. So this is an involuntary manslaughter under the theory of operating the vehicle while intoxicated. So apparently that includes the lesser offense of involuntary manslaughter. Okay. So instead of killing someone while driving drunk, how about involuntary manslaughter as a lesser included? Okay. Yeah. If she didn't hit him, all goes out the window? Yes. Yeah, she didn't hit him, it all goes out the window, because if Karen Reed didn't cause it, then this all goes out the window. So yeah, that's pretty easy. So the indictment on involuntary manslaughter. To prove guilty of involuntary manslaughter because of wanton or reckless conduct, they first must prove defendant caused the death, defendant intended the conduct, so they intend the conduct but not the result. They intend the conduct, and the conduct was wanton or reckless, which DUI is a pretty good example of that, but that's a separate charge. So it could be reckless for some other reason. Again, recklessness is conscious disregard of known risks, even if you're not exactly aware of what, not even if you can't put your finger on exactly what thing, but you know that you're consciously disregarding it. So this is a difference between just not paying attention and consciously deciding not to pay attention, right? There's a difference there, right? So, yeah. So the first element of the involuntary manslaughter is the defendant caused the death. A defense act is cause of death where the act in a natural and continuous sequence results in death, and without it would not have occurred. We heard that before. So actual cause, but for causation plus proximate cause. So if there's a interruption in the sequence, it doesn't count. All drunk driving is wanton. Yeah, I think that's fair. That's why it's lesser included. Yeah, that makes sense. Yeah, I think to say all drunk drive, well, at least reckless. So I don't know necessarily if it's wanton, but it's definitely reckless, and they're the same thing. So to the degree there's a difference between wanton and reckless, to the degree those are different things, then yes. All drunk driving is reckless, but not necessarily the other way around, right? You could be reckless because you're just going really fast. You could be reckless because you're, weaving in traffic. It could be reckless because, you're just, whatever, doing drag racing or something. There's a lot of ways to be reckless without necessarily being drunk. So yes, all drunk driving is reckless, but not the other way around. It's wanton or reckless. It's wanton or reckless. Wanton or reckless. Which they may be the same thing. But it doesn't matter. So anyways, the first element is defendant caused the death. Okay, we understand that, both as a proximate cause and as an actual cause. The second element is the defendant intended the conduct, right, but not the intent of the death. So in this situation, I intend to cause the conduct, but I don't intend to kill. But I'm trying to do the thing, okay? And that conduct is wanton or reckless. So for example, the Rust shooting might be an example with Alec Baldwin, right? That might be an example of involuntary manslaughter, which it is, because, well, perhaps that's going on, right? It's not that I desire to kill, it's that, that I handled a gun and did so unsafe and so forth and so on. So, whatever. No, you're fine. You're fine. I don't mind questions. That's why we're here to try to teach and explain and try to demystify this a little bit by going through it in steps. So fair enough. All right. And so they define wanton or reckless a little bit further. So that's fine. Wanton or reckless conduct is conduct that creates high degree of likelihood substantial harm will result. It is conduct involving a grave risk of harm to another person that the person undertakes with indifference or disregard of the consequence. So that's basically what I've been saying, right? You're aware of risks, perhaps not specifically a particular risk, but you're aware that this is a bad idea, right? If you said, is this a good idea or a bad idea? It's like, yes, this is a bad idea. Harm will ensue. What specific harm? Not sure, but that's kind of recklessness, the conscious disregard. There's going to be a grave harm and you don't care. Or you don't care, or you actively choose to ignore it. Either one will be fine. Whether conduct is wanton or reckless depends on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant doesn't know it, then it doesn't count, because you can't be reckless if you're not aware of a threat. Which is arguably, for example, exactly what Alec Baldwin will be arguing, I would imagine, in his trial. It's like, yes, I wasn't reckless because I didn't consciously disregard a known risk. I had every reason to believe that gun was safe, and so forth and so on. So this is exactly where this is, I would imagine, going to boil down in the Baldwin trial. I would think. Legally, that's what my expectation is. Right? If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of the grave danger. So as long as the defendant knew, that's enough. Right? Even if a reasonable person didn't know, if the defendant knew, because it's all about her conscious disregard. Right? So even if a reasonable person wouldn't have known, but the defendant actually did know, and you can prove it, you're there, because they disregarded a thing. So you're there. Right? Even if the defendant herself did not realize the grave risk of harm, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act and posed a risk of grave danger. So even if the defendant didn't know, if a reasonable person would know, then you're supposed to know, because everyone has to be at least a reasonable person. If you're more than the reasonable person, great. So if the reasonable person doesn't realize, but you do, cool. If you don't know, but the reasonable person does, also cool. Because you have to be at least as aware as they are. If you're more aware, fine. And then you're guilty. If you're not as aware as a reasonable person, well, you have to be. That's just, everyone is expected to be the reasonable man. Easy enough, right? No problem. In order to prove the defendant acted negligently, it's not, or they say it's not enough to prove negligence, which of course it's not. Right? We're talking about reckless conduct. We're not talking about an accident. We're talking about speeding at excess, weaving through lanes, drunken driving, and other comparable examples. So in determining whether the defendant knew or should have known, you may consider any credible evidence the defendant suffered from mental impairment or was affected by the consumption of alcohol. A defendant may have the requisite knowledge even if they consumed alcohol, but you must consider such evidence in determining whether they've proved it. So fair enough. But then again, you can determine whether the reasonable person would have known if they weren't under the influence, and then you're there. Okay, then we also have the lesser included offense of motor vehicle homicide, felony OUI, liquor and negligence, which I assume we're also charging, I guess. I think. All right. I seem to specifically mention them talking about the OUI, and I thought they weren't bringing it. So I'm very confused right now, but let's assume that it exists for the moment, and we'll press on. Is the jury back yet? No? All right. The offense of manslaughter while operating a motor vehicle under the influence also includes the lesser offense of motor vehicle homicide. As a matter of law, the indictment that's before you, which charges the defendant with manslaughter while operating the motor vehicle under the influence, also includes the lesser offense, because the parent has all the elements the lesser does. So fair enough. The Commonwealth may prove the lesser charge of vehicular homicide even if it fails to prove the greater charge. Makes sense, because it's lesser. You may find the defendant guilty of vehicular manslaughter homicide only if you're not convinced beyond a reasonable doubt they're guilty of manslaughter. So, because, well, if you found them guilty of the parent, it necessarily is guilty of the children, so you don't need to think any further, right? Because it necessarily must be so. EM gives me some hippos for €5. Thank you very much for the hippos. They are extensively appreciated. Thank you also, Literal Lena, for the gifted memberships, and thank you, Apocalypse Fra, for the gifted memberships. I appreciate all your support as well. All right, so in order to prove this, we must prove the following. Defendant operated the motor vehicle. She operated the motor vehicle upon a public way. That while the defendant was operating the motor vehicle, she was under the influence of liquor and or defendant's blood was greater than 0.08. That while operating in a negligent manner, she did so that the lives of the public may be endangered and that such operation caused the death. Okay, 1, 2, and 5 are 1, 2, 3, and 5 are the same. The difference is the fourth element. Okay, so here we're talking about just pure negligence rather than recklessness. Okay. So we're talking about negligence, which is pretty easy to prove, right? That's pretty easy to prove. I mean, if it happened, it's almost invariably negligence because, you know, you're not supposed to hit somebody with your car. I mean, it's hypothetically possible for it not to be negligence, but, you know, that's kind of difficult. You know, if you hit another car or if you hit a person, you're not supposed to do that. So hypothetically, it's not negligence, but probably is. So yeah, I agree. It seems a little bit out of place because it's just strict negligence. So in order to prove that, the Commonwealth must prove beyond a reasonable doubt that they acted negligently in a manner that might have endangered the lives of the safety of people. A person acts negligently when they fail to use due care. That is a way a reasonable person would not act. So this is just your garden variety negligence, which is pretty easy. If it happened, it's almost invariably negligence because, you know, it'd be a very strange hypothetical for it not to be. I mean, it could be because, for example, a situation where it would not be negligence would be if the other person like threw themselves into the car, which has been known to happen, for example, for insurance fraud, right? So that would be an example where a car hits a person, but that's not negligence. Why? Because the person themselves threw themselves into the car. And that, you know, no one could reasonably anticipate that someone would do that. So that would be an example where it's not negligence, the actions of another person. Another example where it's at least hypothetically possible would be a situation in which you are exercising due care, but a sudden thing occurs that is completely unpredictable. You know, maybe there's a vehicle accident, you know, and a car comes completely flying out of left field and you hit the car, right? And that was completely unpredictable. A reasonable person just driving shouldn't have the burden of predicting such an unlikely thing to occur. So there are circumstances which it would not be negligence, but those circumstances are pretty out there. So I hope that explains that. So how can you determine if she's driving under the influence knowing that the victim took the high risk and agreed that she be driver? Doesn't matter. It doesn't matter if the victim agreed that she be the driver. It doesn't matter because she was the driver and the burn's on her. So it doesn't matter. So it doesn't matter because she made the decision. She should have said no, not yes. Yeah, that doesn't work. Defendant acted negligently. She drove in a way that a reasonable person would not have, in doing so create unreasonable danger. Defendant's intent is not relevant to negligence. The Commonwealth is not required to prove the defendant intended to act negligently, which I'm not even sure how it's hypothetically possible, how you could intend to act negligently. I'm not sure what that would mean. In determining whether the defendant drove negligently that might have endangered lives, you should take into evidence speed, operation, physical condition, blah, 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 blah. You guys know what negligence means. And then finally leaving the scene of an accident. So that she operated the vehicle in a public way, collided, resulting in injury, and that failure to take stops and provide name, address, and registration number, and failed to do so for the purpose of avoiding prosecution. That's pretty easy. We don't need to clarify that really anymore. All right, so that should be a fairly good rundown of the charges that are pending. So thank you very much, Kestrel, for that, because that is the listing of the charges. And I do very much appreciate her and all the mods that make my life just a little bit easier. All right, now let's see if we can find the sentencing guidelines. This shouldn't be too hard. Sentencing guidelines. And so I can tell you what the predicted range would be for these various things. All right, let's see. Okay, criminal history score is going to be 0, I'm assuming. Offense level. All right, so to determine offense level, locate the offense on the master crime list. Okay, or the general law reference. Okay, fine. I'm going to look up the master crime list. Cool. All right, master crime list, Massachusetts. Let's see. No, you did great, Kestrel. You did fantastic. I was praising you. I hope that was clear. I was praising you. You did fantastic. You're awesome. If my praise was not readily apparent, allow me to correct it. You did great. You're awesome. You're the best. All right, let's see if we can find. Oh dear. Oh no, you did great, Kestrel. You did fantastic. It's what I needed. It's what I needed. You did great. Okay. This is a mini master list. I don't want a mini master list. I want the list. What is a mini master list? What bullshit is that? Oh, no, it is the full list. Okay. So let's see. How do I find these things? I'm assuming murder in the second degree is life, but I'd actually like to look it up. All right. Oh, Lord. It's by chapter number. Okay, that's cool. I can look it up that way. All right, fine. All right, so let's see. All right, so 265 section 1. All right. 265 section 1. 265 section 1. Come on. Just give me one. 2, 6, 5, 1. Murder second degree. No, not by a minor. Murder second degree. All right. 265. Murder second degree. All right. Mandatory time is 15 years. Minimum prison is 15 years. The maximum prison is life. Okay. Interesting. And now, is that the end of that? Oh, this is offense level 9. That sounds bad. All right. Staircasing. Certain offenses may cover a range of conduct that have been staircased. Okay. Ranking misdemeanors, second convictions, degree of injury. Scale. Figure 1. Permanent injury. Well, I mean, that's 7. I mean, that's easy enough. This is death. Let's see. I need my table. I need my chart. Okay, no. Murder sentences. Okay, if they do life imprisonment for crimes other than first degree minimum, not less than 15 to 25. So apparently if it's life with a parole available after 15 or 25 years. If they give life. So it's life with parole. I don't think life without parole is available for murder in the second degree in this state for second degree, if I'm reading this correctly. I put it on screen, but it's not very friendly, user friendly. So I'll just do it the hard way. All right, so I'm going to say 15 years is the minimum, and then they can issue life, at which point I think it's life with parole. after either a minimum of 15 to 25 years, if I'm understanding this correctly. No repeat offense modifiers. No, because these are all done at the same time, so they shouldn't stack like that, I don't think. So no, I don't think so. All right, so 265, 13 and a half. That's a very strange section number, but okay. 13 and a half it is. All right, manslaughter while DUI, 5 to 20. So that has a max, 5 to 20. So minimum 5, max 20. Okay. The third offense, involuntary manslaughter, which is just 13. 2.5 to 20. Okay. I mean, all right, fine. So 2.5 to 20 for involuntary manslaughter, which is also the same as voluntary manslaughter, incidentally, in the state, but okay. What's my favorite pro se argument that's actually good? I can't think of any off the top of my head, but the best pro se argument of all time is Crawford is right to an attorney. Bradley? No. What's it called? Gideon versus Wainwright. Gideon versus Wainwright. Best pro se argument ever. I mean, he got the Supreme Court to take his case pro se. So, you know, and then he won. So, you know, you can't do much better than that. $10. A junkie in my town in Massachusetts hit a driver. He got 2.5 to 4. After very obviously doing it and trying to cover it up by driving down to Connecticut to get work done. Pled to homicide by negligence. Fair enough. Yeah. Gideon versus Wainwright. Yeah. Best pro se ever. He got the Supreme Court to overturn his conviction. So, you know, that's the winner. Let's see. Now, where else were we? Okay, so we did manslaughter of the motor vehicle. We did that one, 5 to 20, and then we did involuntary manslaughter, which is 2.5 to 20. Okay. All right. Then we just have involuntary manslaughter. Well, that's the same thing. We just discussed that. Okay. So that's 2.5 to 20. All right. Next. Lesser included a felony OWI. All right. So this is 90-24. All right. Hold on. As I go look up in the table. $90-24 GA. Okay. This is 2.5 to 15. Mandatory minimum. Okay. Mandatory time is 1 year. So, but then a sentence of 2.5 to 15. But you have to actually serve a year. So I don't think the other one had a minimum, but this one does. So this one is 2.5 to 15, but includes a year in prison. One more thoughts on Colin Albert theory. I mean, I think it's plausible. Yeah. So 2.5 to 15 is basically the long and short of that. We'll keep it simple. Then let's see. OWI 90-24 GA. We just discussed that. And what else is left? Leaving the scene of an accident. 90-24 to 8.5 2. Leaving the scene of an accident. 2.5 to 10. So there you go. You now know all the things. You now know all the things. It also includes a year in prison of mandatory time. So now you know everything there is to know. So the top count is 15. Is that what we said? 265-1. I'm surprised it's so low, to be honest. In many states, that'd be life imprisonment without parole. So Massachusetts is nice, I guess. It's a good place to commit a murder, I guess. 265-1. Just double check this before we close this little chapter of our lives. $265-1. 20 years. 20 years to life. Okay. Yeah, 20 to life. No, wrong. Sorry, wrong one. 15 years to life. Yeah. So 15 years to life, it looks like. Yeah. So, okay. That makes sense. So 15 years to life for murder in the second degree. So that's what she's facing. Top count. And then other stuff that's not serious. So fair enough. Good times. That was exciting. And you would think you would think that she's going to get like 30 years or something. I mean, probably not life, because I mean, this isn't a cold-blooded killing, so probably not life, but she's going to get probably 20, 25 years if I had to bet. I don't know what it means in terms of suspension of your license. I'm sorry, I didn't look that up. That was not my primary concern. So if you want to figure out what it means for your license, you can look that one up on your own time. All right. So what else can I... Hypothermia is the very definition of cold-blooded killing. Ha, 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 ha. All right. So... yeah. So what should we do? Can you ask the difference between a grand jury and a jury now? Yes. A grand jury, the jury now is the petit jury. Is the jury of now. It's called a petit jury. A grand jury is an investigational tool. In half the states, it's been abolished. In the other half of the states, it's only used for particularly serious offenses. And in the remainder, it's used on a more sporadic basis. So it is an investigation tool. And different states, as I say, vary about what they use it for and what they don't use it for, if they use it at all. But the grand jury only hears from the prosecution. They only hear from the prosecution. It is typically 23 people, and you only need 12 of them to agree. So you need half. You need half of them to agree, and they only have to agree to a probable cause standard, which is like 1 out of 10. So it's very easy. It's an investigation tool. And it's a bit... it also can be used... It can also be used more broadly as an investigation tool, like before they're going to bring an indictment, so they don't necessarily have an indictment in mind, because it allows them to put people under oath. So it could be used to investigate a crime, because they want to, call witnesses under the penalty of perjury. So it could be used more broadly as they're just investigating a particular crime without any particular charges necessarily in mind, and that may or may not result in charges at the end. But it's an investigation tool. It's a trivial investigation tool. And these days, the police basically handle all that stuff. It's a group of citizens just like anyone else. Also, the grand jury serves for a longer time, and they hear a lot of cases, so they just don't hear one case typically. You can do that. It's called a special grand jury, but that's atypical. Most of the time, grand juries sit for 6 months, a year, and they just hear all kinds of cases. So that's what they do. How often do judges overturn verdicts? Very, very rarely. Of course, in a criminal case, they can only do it one way. They can only overturn a guilty verdict. And I wouldn't get my hope up that this particular judge is going to do that. So, yeah, I don't have my hope up. We looking at the physical jury instructions? We did. We looked at the Commonwealth's proposal, and we read through them. And it gave us everything we needed. So we're good. We got it. We got it covered, Tony. Yeah, it's very rare. Yeah, and the proposed instructions gave us everything we needed. because the proposed instructions were exactly the charges that were given from the bench. So it told us what we needed to know. So it was perfect. It was exactly what I needed. Kestrel did a great job. 6 to 12 months for the grand jurors paid a living wage? No. You'll do it for free because you're a good citizen. $5 a day. Yeah, no living wage for you. So what else should we do now that we're on verdict watch? Now that we've covered everything there is to cover, we could do some Supreme Court stuff. Okay, we can either do one of two things. We can, what is your pleasure, guys? Would you like to do some Supreme Court stuff? Or would you like to edit something in the hope that maybe there will be an edited video? Because I don't have anything for today. So should we edit a video for today? In case I need it, so it can go out today? Should we edit a video? Or should we do a Supreme Court thing? What do you guys think? Edit Lally's closing? No, that's okay. Well, I'm not going to edit. Oh, you mean edit the closings? No, probably not. Well, I could try to edit the closing. I'd have to I'm not sure how I'd go about that, because like cutting down the closing would be really challenging, both ways. It'd be okay. Let me help you out on this one. All right. All right. Let me make sure that you understand the implications of what you're asking for, because I'm not sure you've necessarily thought this all the way through. If I edit the closings, it means we have to re-listen to Lally. You do understand that, right? You do understand that if I'm going to edit it with you, we're going to have to rewatch Lally. Did you think about that part? And we have to listen to him several times, right? Just the defense, torture, no Lally. We can suffer together. All right, we can. All right, Tony. Should I edit the defense close, or should I edit the expert? What makes more sense for tonight? Your daughter's going to Clemson? Go Tigers. It's a good school. We'd have to probably do a reaction. We'd have to like redo it. But that's okay. You probably wouldn't mind it. Okay, we'll go listen to defense close. That's fine. We'll listen to it. Who's my most effective witness? Tow truck. I mean, the snowplow driver is great. I mean, all the defense experts were pretty great, but you know, snowplow driver definitely has a place in my heart. He was just a simple man, a simple, ordinary, average man telling the truth, man. You know, it's like snowplow driver is still my favorite. All right, fair enough. All right, we'll go rewatch the defense, and depending on your mood, maybe we'll go rewatch Lally. I don't know, maybe for good, we'll go rewatch Lally. All right. All right, let's stop the recording there so I can do a new recording. All right, let's bring it up. I guess I can just go backwards in this feed. I don't need to like make my life more complicated. All right, so just go here.
Thank you, Your Honor.
All right, cool. Shut up. All right, let's see. Okay, full alt. Oh. All right, okay. Let's give this a shot. Me, 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 me. Me, 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 me. All right.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way.
All right, really strong opening here and really strong thematic elements. This is really good. So in the same way he started his opening with Karen Reed was framed, strong thematic, strong element, he chooses the phrase look the other way as his thematic element. And so he echoes that phrase several times and gives an example. So this is an example, once again, of a very strong, powerful opening. He starts with a simple phrase. In the opening, it was Karen Reed was framed. Here, it's look the other way. It doesn't have to be complicated, and it's not complicated. It's very simple, sets the tone, and establishes a strong theme that will carry us through. So, outstanding job, as always, right from the start. I am intrigued.
Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice.
All right.
It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America.
All right, there you go.
The government stop answering to us, and we start answering to the government.
I mean, you know, I love the patriotism and the spirit. That probably goes better even in Boston, in the Boston area, because, you know, of the whole Tea Party and everything. So that strong, independent spirit. I love it, man. That's good stuff. I like it.
And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor.
Truth.
Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third.
Yep.
This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions.
Nice.
What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time.
I really like the poetry. Very good there with a nice quote there. And then he follows the quote with this nice verbiage, this very rich language, the malignancy, cancer, very descriptive, very evocative. It's very, very thoughtful and very caring language. It's just very solid language. And so I really appreciate the way he follows that with such rich language. It shows a real mastery of the English language. Shows someone who actually thought their closing through. Nice job.
And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie.
Powerful, very
Over
nice.
and over and over. They and others were caught deceiving you. Big things, small things. It didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way.
I mean, really, what can you say there? Really, it's just a nice choice of exemplars to bring the point home. Look the other way is what the state wants you to do, and here are a couple examples. Doesn't overstay its welcome either. I mean, he could have gone into more examples, but his choice to make them a little bit more tailored is also a very logical choice to not overstay its welcome. And I think he gets in and gets out in a very powerful way. So good choice. Could have tried something different as well, maybe a bit stylistic about which you prefer, but his choice was very solid, giving some nice concrete examples of things that they just want you to ignore. So I appreciate that.
Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that could happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person, and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry, and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl.
All right, for my money, this part of the closing is my personal favorite part of the closing. And if anything, I would only want it to be a little bit more enumerated and a little bit more broken out because it was so powerful. But I really like the way that he just basically goes through, here are all the reasonable doubts in a very long list. And he shows basically all the reasonable doubts, just one after another, after another, after another. And he really does very well with the pacing. At points he pauses so he doesn't step on his own lines. He's very good with enunciating. He's very good with his vocal variety and presentation, very good with his energy. And he breaks it up in a way that makes it very easy to listen to. This went on for quite a while. It was quite a long time on tape. It was, 2 minutes, 3 minutes that segment went on, but it was just so easy to listen to. And basically distills everything and shows you all the evidence at once. So it's like, if you needed reasonable doubt, here's reasonable doubt 50 different ways. And so I just really like that at one point in this closing argument, he just puts them all together, and so that you can see them all together. And then, of course, we'll talk about them more in detail later in the closing, but to just show them all together and show them all at once so that their accumulated mass is more apparent is a very, very strong move. Maybe my only thing that I would have done differently is perhaps number them so it's more explicit that how many there are, so that you could actually count them, and then I could refer to that number at a later point in the closing so I can actually say it. But other than that, and that's just a stylistic change. Other than that, this is my favorite part, just smashing the state all at once, all in one go, and you just see the holes in the colander appear. It acts as a sieve, and the case just falls through. Brilliant work on this close.
It's not that it could happen. It's that every single one of those things I just mentioned did happen.
Yep.
Right in front of you.
Yep. There you go, baby.
But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall.
Mm-hmm.
What are the words that every single person who testified in this case used about Karen Read and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up into the time Karen Read dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble.
You gotta love that. You gotta love that, and it's very illustrative and very true. We've all said things, I'm sure, in various relationships in the heat of the moment that we didn't really mean, and perhaps were too aggressive. And yeah, so everyone describes them as in a good mood and having fun and lovey-dovey and all the rest of it. So are there some voicemails in which you might be a bit aggressive? Perhaps there are some voicemails, but if that's enough to condemn someone for murder, yeah, we're all very, very in trouble indeed. A very good illustrative point. Takes the wind out of sails, basically attacks motive as non-existent. Good stuff. Very good work. Excellently done.
Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And then when he was caught and asked to describe that man, he had to. It was a little bit vague, but you remember what he said. He was tall, with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial that was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data, look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monotonic time, it aligns perfectly.
Really effective use of the evidence here to explain how the health data and other data align to show that the victim was taking steps, including doing flights of stairs, which everyone said he wasn't in the house, but his own health data says he was because he's climbing up and down stairs. And what stairs are there? Not much except inside the house. And then there's like, okay, there's a contradiction, but no, there's not, because if you just offset the time, then they line up perfectly, which makes sense because not everything records perfectly on the same time frame. So, you have to adjust the time interval. It's like, oh, okay, so it all comes together. Really good command of the facts, really good command of a perfectly objective piece of evidence to show that he was in the house, despite the protestations of all the people who said he wasn't. Good work.
They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30. And John's...
Well, that's a bit of a blow on the state's timeline, isn't it? Her phone connected to John's Wi-Fi at 12:36. So she had to be there. And since it's a 6-minute drive, she had to be gone by 12:30. That's a bit of a blow to the state's timeline. Yep.
Phone was taking 36 steps and logging 25 meters at 12:32 after she'd left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it.
Yep.
But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie. And Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial.
Yeah. No.
How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing?
Yeah, multiple butt dials is a bit of a unlikely explanation. A singular butt dial, maybe, but multiple different butt dials that all apparently, trying over and over again. That's a bit of a unlikely explanation. I do appreciate throwing Skeletor under the bus over here. That makes me very, very happy because this woman was what is the opposite of a treat on the stand. So yeah, that's good work. I appreciate that.
Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They'd been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You could see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done.
Yep.
His text message, well?
Yep.
Meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night?
Yep.
And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers.
Yep.
Remember that testimony.
Yep.
So what happened next? We absolutely know that John was in the house. The data, Ryan established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, you know, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10?
I really like the way he walks through the crime scene interior in his telling of the story. And he's just a fantastic storyteller. He has 2 really good traits as an attorney that are really admirable. One is the attention to detail, because he knows the minutia. So really good attention to detail. And 2, he's really good at storytelling. And those are really good qualities. And here he brings out those traits. He brings out the attention to detail to walk through all the players, including Chloe, talks about how these people left the room, talks about how there was a desire to bring him to the scene of the murder, how the one person seemed to want to get with the girl, and there might have been a crossword, and how long does that take? And he just walks through it and he talks about how Chloe was on the ground floor, possibly leading to the scars on his arm. Yeah, I mean, it's just really good attention to detail, and he puts it together in a very easy to listen to, very engaging story. This is, if you can get story right in your opening and your closing, you're there, baby. And this guy knows story. It's a master's class. It's fantastic.
Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First he said it was administrative work, then he said he was moving cars, then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted, yeah, I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall.
Yeah, Chloe, the dog, hashtag justice for Chloe, as she has been rehomed to a farm in Vermont. Yeah, the family dog they had for 7 years, who had a bite history of other dogs, who the family says wasn't good with other people. And we have scratches in the arm that look suspiciously like they might be dog scratches. And the family dog just so happens to not be available for any sort of review. Some rehoming going on. Chloe, wherever you are, you got done dirty. Hopefully justice will be brought to you someday.
All what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day, at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough, in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street.
I'm working here.
Lally asked Sergeant Buchanan. Come up with it was a typo. There's still no response. By getting along, no issues, good mood, happy, affectionate. Another thing called ways, calls happening. They both claim astonishingly that those calls are, timeline seems to fit, doesn't it? And it fits a very neither. And second, the only at the end of the search became a focal point. Talked about. Jennifer McCabe is on her. All right, don't talk to anybody. And Higgins seemed okay, fine. And by the way, done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google search call. Behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow.
Yeah, snowplow man.
And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, He didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was no body on that lawn, period, at 2:30 a.m.
I think Snowplow Man is my favorite witness of the trial. A simple, normal, unpretentious, down-to-earth man. I love this guy. He's just a normal guy, uncomplicated, and he's like, "Yep, I drive the snowplow. It's what I do. I passed by the house 3 times that day, 2:30 in the morning being the first of them. Not so much with seeing a body, no. No. Very, very clear. Very, very clear." Excuse me.
And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very... And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered.
Yep.
Who's the only person in this case that you've heard about with a Ford Edge? Brian Albert.
Inconvenient
Remember,
fact
as you're
there.
thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John, he walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back, he's not responding, minutes start to pass, 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. And being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up, she's realized that he hasn't come home and he hasn't responded to a single text, not a single call, and anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered, and her worst fears are realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You could see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What?
I tend to agree. That doesn't make a lot of sense. I mean, that doesn't sound like normal behavior. I mean, you might think a call maybe to like cover your tracks, but 53 calls by this person is like, I don't think so, man. Yeah, it sounds more like someone in a panic, desperately trying to figure out where this person is than a cold-blooded killer. That doesn't make sense. I tend to agree. So, yeah, it doesn't really add up, Commonwealth.
What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth?
Nope.
The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there
Yeah, you know, if this is the taillight at 5:07 in the morning, which it is, it's caught on video apparently at 5:07, I'm seeing an awful lot of red brake light. An awful lot of red brake light. Yeah, that looks pretty intact to me at 5 o'clock in the morning. Kind of difficult to see how that squares with the state's timeline that the lens, the plastic cover shattered. It shattered so hard, this plastic carbonite, which is designed not to shatter at all, by the way. It's designed not to shatter at all, but never mind. Somehow it shattered, and shattered so into such sharp pieces that it created these deep knife-like things to cause the wounds in his arm. And that happened several hours earlier than this, but somehow when we look at it, not so much, the taillight actually looks intact. Yeah, no, that seems like a bit of a devastating image to the state's theory of the case. Not really seeing a broken taillight there. Looks normal to me at 5 in the morning. Seeing some problems with the state's theory of the case, it seems to me.
was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn officer, he's not associated with Kenton, he's not associated with the Alberts, he's not associated with the McCabe's, he doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked, a piece was missing, but not completely damaged." Take a look at this photograph.
I mean, that does seem to be like the photograph we just saw. If you could even say cracked, I can't really tell from the photograph, but yeah, not so much with completely damaged. The completely independent cop says it looked only cracked to me. Maybe missing a small piece, but looked mostly okay. That seems to be more reflective of the image we just saw at 5 in the morning on the camera. Unless we think the camera lies. But, you know, okay, sure, fine.
Tell me, which one looks like Officer Barros's description?
Yep.
The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so.
Yeah, this image seems to be more reflective of the image I just saw from that camera at 5 in the morning. Seemed like the taillight was pretty intact to me. So if you said which of these taillights is more reflective of the image we saw at 5 in the morning on the video, is the left one more indicative or the right one more indicative? I saw an awful lot of red on that image. So I'd say, yeah, probably more like the left than the right, because I could see red, clearly red. But who am I to believe? Me and my lying eyes, I guess.
You'll recall that after John's body was discovered, Lank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades.
Yep.
At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud.
They sure did. They sure did. When this is all over, we need to get Proctor a gift. The guy that was investigating. The independent guy. The independent guy who's investigating them, who knows the family and goes back with them for decades. We need to get that guy a gift. Yeah, maybe not as independent as otherwise first indicated. It seems possible, yeah.
But still, you've got to imagine that the Alberts had to be stressed. What with that whole thing about a dead body being on their lawn. That might get some attention, and they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a...
Yeah, that pretty much sums it up. Feel like the investigation could have potentially been a little bit more thorough. Feel like perhaps some additional investigative steps might even be readily apparent, and perhaps we should have pursued those. But Michael Proctor is here, and he's got the case cracked 18 hours in, and he doesn't need to do any of those pesky investigation steps. All right, sure, yeah, I'm sensing some problems here with the state's case in every possible way.
Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall.
Nice. Respect.
A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them.
Okay, I just have to say, I have to take a moment here to just say, I really appreciate the way he just said the same thing like 6 times in a row. It's that whole repetition is the mother of learning thing. And he does it masterfully. He talks about the thin blue line being the thin blue or the big blue wall. And then he says basically that exact same thing, but 6 different ways, right? One after another after another. And it is just a masterful way of making sure the point gets home and not get lost. Repetition is the mother of learning, as my high school history teacher reminded me repeatedly. And this attorney has learned that lesson. Repeat to the jury, make sure they don't miss it. Tell them 6 different ways to make sure they didn't miss it. Very, very good rhetoric, very good illustration, strong choice of language, evocative, imaginative, visually resonant. Really, really nice moment there. Good work.
And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption.
Yeah, no, fair. It's a little bit difficult to say that it happens over and over and over again, so it's merely incompetence or a mistake. It's much more suggestive of a deliberate intent to not care and not look. Reckless disregard of his duties, or even intentional disregard of his duties because he was trying to protect the Alberts. Yeah, very, very sharp, well observed, good work. This attorney is fantastic. Let's listen to some more.
The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo.
A lot of typo.
A dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m.
Yep.
That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Loughran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report.
Yep.
He hid him.
Yep.
This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out?
Yep.
Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Loughran.
That is fantastic. This is a potential eyewitness to the event. one would think the police would want to interview potential eyewitnesses to the event. Maybe he didn't see anything, maybe he did, but you might want to check with potential eyewitnesses. Seems like, that's something that police would want to do. And Proctor knew the guy. He knew his name. And he made no attempt to interview the snowplow driver. No attempt. It didn't even appear in any of his reports. Didn't even appear, and the name didn't even appear. It's almost like he was trying to hide something. It's almost like he didn't want to look. It's almost like he was trying to hide an inconvenient thing that might somewhat change the narrative. Yep. Nope. Yeah, it seems like a deliberate intent to conceal. Yeah.
That's a scary prospect. I want to touch briefly on the additional physical evidence or some.
Skeeve man gives me 10 pounds to say, take my money and hit me with that law, daddy, Uncivil. You know it, baby. You know it. Thank you for your 10 pounds. I do appreciate your and everyone else's support.
Additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself.
Yep.
And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass?
Preach. Preach. One of the pieces that was supposedly found on the bumper also happens to match a piece that was supposedly found at the crime scene. Who possibly could have done this? Who had possession of the car? Who was it? Who could have done this? How did that piece get there? Yeah. I'm sensing some potential malfeasance by some governmental actors on this one. Sorry, Sky, for mispronouncing your name. Sky Veman. Hi, Sky.
Michael Proctor. So the glass on the bumper had to be placed there, and the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math.
Yep.
That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. That magic hair means nothing.
Pretty much.
The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces. And no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure.
Yeah, I mean, it should be fairly obvious that those pieces, that the plastic on that is somewhat designed to not shatter into 1,000 pieces. It's built for that, to not shatter into 1,000 pieces. But so that's one thing. And then second thing, none of those pieces, which apparently, again, according to the state, according to their theory of the state, it is the shards of the plastic which somehow shattered into knife-like pieces, like plate glass. So apparently we are confusing plastic for plate glass somehow. And these knife-like pieces cut up his arm and made all the injuries, yet we found no blood on any of the pieces, nor any tissue on any of the pieces. And these are the pieces that are supposed to have caused these arm injuries. That doesn't seem very plausible. I'm having a very difficult time with that one. Not one drop of blood, despite the many shards cutting up his arm. Not one drop of blood on any of the plastic or one piece of tissue. Yeah, no, I'm not really buying that story, government. Not feeling it.
We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them.
Yep.
Look at the video of the Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think?
Yep.
Did someone not want you to see what the condition of the taillight was at that exact time?
You gotta love that. You've just got to love that. The video just happens to be missing the exact time of the arrival of the car, which would show, for example, the condition of the car, and just happens to be missing that segment of time. What are the odds?
But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that one was turned over.
Yep.
And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight, while he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward.
Yep.
And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally. That was not a mistake.
Yep.
And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way.
Yep. Well, I like that segment, right? So he starts with the videotape and how the witness said, oh, it's all fine and everything's great, but finally confronts him and proves it's inverted, and then uses that idea of that deception to then merge into a broader idea of deception, and then capstones the entire segment with that phrase, just look the other way, re-echoing the explicit theme from the start of it and brings it back home here to emphasize the point and brings in the theme. This guy is one of the best storytellers for lawyers I have ever seen in my life. He is very, very good at story. He's very rich with his word choice and vocabulary. It's visually evocative. It's emotionally evocative. He repeats without it being repetitive. He uses slightly different words or slightly different ideas to echo the same point so you don't miss it. Brings in the theming, brings in the idea, moves from topic to topic in a way that's extremely followable. I mean, as far as storytelling for lawyers go, this guy is masterclass. I mean, you could do it a different way. It doesn't have to be done this way. There are other ways to go about it. So there might be other ways to do this in a way that would work, but this way is masterclass. So just bravo all around.
And don't forget, Buchanan is Proctor's supervisor, and he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0.
That's pretty suspicious.
Stephen Seraph, Sean Good, Stephen Mullaney, Michael Lank, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower.
Can't forget the leaf blower. It's critical, my friends. Leaf blower is best.
Not one piece of bright red taillight material was at the scene. Not a single piece. But incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found. Some of which...
That's a miracle, right? We went from no pieces being found by 5 officers who were working the scene. So 5 officers can't find a single piece, and somehow 47 pieces. But that's not suspicious in any way. Lol.
Which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found. About 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about, those 3 pieces, red, clear. So this must be real evidence, right? It must be real evidence. Asked about, look closer, not out of the bag. So miraculously, trooper, right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how, over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47.
Yep.
Ever increasing in size with every single search.
It's a miracle.
Now, knowing all that, ask yourself the looming question: who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37. And see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara? Unidentified troopers in Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, and now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses, and expended 30-plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe, or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car.
Yep.
That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto-pedestrian accident. That by itself is reasonable doubt. But the evidence...
I mean, pretty much, right? Pretty much. The state's own medical examiner said that these injuries are not consistent with a pedestrian accident, which of course they're not. No bruising, no broken bones, no fractures from a 7,000-pound car going 25 miles an hour, all hitting his arm. Not sure I need an MD to reach the conclusion that 7,000 pounds of car going 25 miles an hour, all hitting his arm, should probably leave some sort of bruising and probably more severe damage. And even the ME has to confess the truth because, yep, pretty much it's bullshit to say this was done by a car.
And the truth goes far further. We introduced you to not one, but 2 thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Mm-hmm. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident.
I mean, that does sound like a lot of credentials between the two of them. The triple credential, pathology, emergency medicine, all the rest of it. Sounds like these guys might know what they're talking about. They don't buy it. Yep, that makes sense.
They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rentschler, mechanical engineer and a biomechanist. They reviewed this case, they did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth.
But do they have an associate's degree?
They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period.
Yep.
And that is yet another fact that establishes reasonable doubt and should put an end to this case.
Kind of sounds like reasonable doubt to me. I mean, you know, they got two MDs and two engineers with many degrees. One of the MDs literally wrote the book on animal bites. One is a forensic pathologist, studies this stuff. One is a biomedical engineer. One's a mechanical engineer. This is what they study. They do this for their living. And they're all like, nope. When we actually know formulas, we can tell you what the formulas are because we know science. So yeah, I feel like that's quite a lot of reasonable doubt. Yeah, that's good.
So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony.
Yep.
I think I'm being kind when I say that Trooper Paul's analysis lacked credibility.
I would somewhat tend to agree. I mean, you know, he does have that associate's degree, which I don't believe any of the defense's experts had. I don't think any of them had an associate's degree. So Trooper Paul does have that going for him. The only one testifying who has an associate's degree. And yeah, I mean, I found Trooper Paul's testimony at times to be slightly suspect, maybe a bit questionable, a little wanting, perhaps slightly underdeveloped, could have been a little bit more thorough at times, a little bit difficult to fully appreciate, and somewhat, perhaps, if I be so bold, even inept. Yeah, I did leave myself in wanting more. I have to be honest on that one. Trooper Paul wasn't really doing it for me.
Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement before coming to his final resting place with his unbroken phone, tucked neatly under his
Yeah.
body.
Yeah.
It's nonsensical. It borders on laughable.
I disagree. I don't think it borders on laughable.
Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rentschler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rentschler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, "You can't deny the science and the physics." John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero.
I really like that moment by the defense lawyer because he preempts an argument from the state. And he knows that there's a pretty good chance that they're going to say it. And so he preempts it to make it look foolish. So either the state does it and he's preempted it, or even if the state chooses to not do it, he still put it in their mind. So either way, it's a win for him. It's a nice idea, a nice strategic move. Predict where your enemy has to go and defeat them before they get there. Sharp move. Good call. Really enjoyed that one.
They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour.
That does seem literally incredible. As in not credible. Yeah. That doesn't make sense to me either. Under my basic understanding of physics or the human body or reality or anything else, really. I don't buy that one.
And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision.
I do love the shade. I love the shade. The best and brightest, Trooper Paul. 10 out of 10 shade. I'm here for it. Good work, sir.
With that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, a punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Well, this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats
Preach.
illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat. Talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object, and he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it.
Mm-hmm.
And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you, not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies and the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth, and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt and to a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
All right. Let's see what's going on in court. They're saying the jury's coming back in. It's there's a debate about why, but all I see is fan. So while I'm waiting, I'll just do. Do you think verdict? Do you really think verdict? Is it real? Is it really a verdict? Do you know that for sure? Is it really verdict? All right. I'm just gonna do an outro while we're waiting. Well, my friends, that was a very good. Let me try again. Well, my friends, that was a very good closing argument by a very experienced attorney. Outstanding attention to detail, outstanding story, and good follow through all the way around. It was a fun ride, good use of language, good use of illustrative language, visually evocative language, very, very good presentation, nice integration of the evidence, wonderful explanation of all the reasons that there are to doubt this thing, and all the rest of it. So, I mean, this is a masterclass closing. There are other closings by other attorneys that are masterclass, so this isn't necessarily the only way to do it, but it is definitely an exemplar of the style that he was going for. Truly well done, and finding any faults at it are nitpicking. So, and it's just stylistic at that point. It's really hard to say there's anything fundamentally flawed. So, fantastic job by the defense in closing, and hopefully we'll get a not guilty verdict very soon. So, we'll see how this all wraps up as the trial comes to an end. It's like an hour and a half that I've got to edit down. It's going to be interesting trying to edit that down. But there are definitely segments I'm going to skip. So we'll see how it goes. 4 p.m. is a bit early to go home. No, that's when they've been ending for the day, for the most part. I'm hungry. I haven't eaten all day. I'll tell you what. I could use some dinner. I could cook myself some food and eat it. And we could do some editing together or something. Yeah, they've been ending trial around 4 o'clock every day, so that's per normal. Yeah, that's just how they've been doing over there. That's how this court rolls. I've got plenty of food. I've got the meal plan food, so I just got to heat something up. I got the meal plan food that I've been sticking to, trying to lose weight. So I'm doing factor meals, and they've been pretty good. So I just have to heat it up. They're pretty good, incidentally. They're good meals. I'm just watching the fan spin right now. Fortunately, you can't hear the beeping, so that's nice. Yeah, right now all I see is fan spinning. I got fan spin. Texas barbecue, yeah. Long crime stop their verdict clock. Well, maybe they're just done for the day. I don't know. I wish they'd be done for the day. I mean, how long do you need to decide this, really? I mean, damn, it's just like... Never mind, it's ticking again? Yeah. What do I think about the fact that Jim McCabe told Karen he saw her drop John off? Does that mean everyone in the house knew he arrived? I don't know. Not necessarily. I don't know. What's Melanie say?
Everyone, just take some deep breaths.
Let's dream snipe. Let's dream snipe.
Do some deep breathing.
Let's dream snipe Melanie for a second.
Laura will come back and do some, some deep breathing with us tomorrow. Would that be fun and nice while we're waiting? Do some yoga breathing, some meditation.
Remember
that day
Melanie?
that Laura came in and did 10 minutes with us in the morning before court, and some people tuned in and they're like, "What am I watching?" So we all need to learn how to breathe before this starts. So we're going to breathe. Oh, thanks, Adam Drives Helen. Says, just looked at the playlist on Spotify. So great. Love that you made a mixtape to go with this trial. Super smart. Thank you, Adam. There were a lot of contributions. Oh, there's a request from the jury. That's what Court TV says. There is a request from the jury.
Is there a request from the jury? Can we beat Michael Proctor to death?
I started it because I think in song lyrics, so every time a song would pop into my head, I would put it on the list. And there's so many. And then you guys started contributing to the playlist, and it's grown. It's like 6 hours of music. So if anybody needs 6 hours of music to keep them company during a long ride or something,
The jury called a sidebar a
first
little bit,
song
yeah.
on it is "Who's
Little bit,
Afraid
yeah,
of
that's
Little Old
funny.
Me" by Taylor Swift. Because I said one day that song popped into my head and it made me think of Karen. And then I had a viewer from the Ukraine who made a TikTok, and it was a montage of all things that had happened during the trial and pictures of Karen. And these are in the order in which we started thinking in song lyrics. Peter Gabriel's I Don't Remember, I Don't Recall, I Got No Memory of Anything at All. Then there was The Road to Nowhere by the Talking Heads. And of course, the Lollipop song by the Chordettes or the Chordettes, Lollipop, Lollipop, because it kept singing Lollipop throughout the whole entire trial. Coffee Cafe has
Did anyone see Donnie on Direct's stream last night? Did anyone see that? Danny Ann decided, I think she just found out about the trial, and she tried to speed run the trial, apparently. She was on for 5 hours last night, and she was trying to speed run the entire trial, and I think it's quite possible she went insane. It was not a good thing to try to speed run the entire trial. And Danny was like, yes, I'm just going to do this. I'm like, Danny, I'm your friend. Step away from the trial. She's like, I can't do it. People are paying me. It's like, dude, man, I've tried to take this in pieces, and you want to speed run this entire shit show and put it all into your head all in one thing? It's like, oh, no. Yeah, so Danny may be insane. She may be certifiable, and we may need to rescue her from whatever puddle she's currently in presumably in Utah. So yeah.
fan favorite. You guys recommended that one like a million times. And then there was some white lines in there, the original Grandmaster Flash version, which is awesome because
I'm just
a lot
going
of
to
people were theorizing what was going on at 34 Fairview and why there was this big after party. So White Lines was on there.
I'm enjoying not having to be a YouTuber for a minute
by
here.
Leonard Skennard, because
I have to be honest.
Every single one of those witnesses who was on the stand just wanted 3 steps towards the door.
I'm enjoying that I don't actually
Witchy
have to work
woman?
as a streamer for a
You
couple
can pick who you
minutes
think
and
that
let Melanie
refers to.
cover me.
Hima's on the edge of her seat. How are you keeping so calm, Melanie? I'm reading through the song list.
Oh,
That's what I'm
man.
doing. Hello, Princess Mission, one of my amazing moderators. This has been a long, long trial for you guys, hasn't it?
This is what it like to be us.
I love
I
each
appreciate
and every
it.
one of you so much. Linda,
So should we see what
Karen
Andrea
Reed updates
Burkhart
on
is
X's
doing?
showing info and video of the press.
Is Andrea
People shouting
streaming?
Karen, helicopter above. Maybe show Melanie since I can't. Hold on, let's just see what's happening. But I thought she was going to do this in open court.
Just going through the super chats and stuff. I don't resent it.
I'll tell you what, I've said
Appreciate
this
it.
before.
Thank you for the opportunity to
I've said
be
this
able to
before, and
have all of
I'll
these
say this again.
conversations,
Andrea Burkhart, for my
share
money,
what I've learned.
is
But yeah, it's
who I think
definitely,
is the most
definitely a
underrated
lot of
person in
screen time.
LawTube. She is so smart, and she is so thorough. She does a fantastic job of learning about the case, and she is so smart. She's undervalued in LawTube.
Keep my eyes on it. Now I'm seeing
Sound is on in court.
10. Let me pull that
What
up.
bullshit is going on over in court?
See if they're back in.
What's going on?
Boston, here they
What did I do?
Yes, they are back in.
All right, we're back. I'm not sure what's going on, but we're back. Let me put on my hat just in case I need hat time.
This is great, thank you.
Hat time is glorious time for you and me. Baby. There's no one in the courtroom, though, so I'm assuming it's not a verdict. Because you can see how many benches are empty. I'm assuming it's not a verdict. Well, who knows? I don't know. Well, they're obviously waiting for something. And presumably they're waiting for the jury. Because the parties are there. What else are they waiting for, right? Is there a verdict? If it were just, can we go home, they presumably would just announce it from the bench. And it'd be like, sure, you can go home. So it's like, okay, what are we doing now? Are we doing verdict time? We might be doing verdict time.
All right, jurors. So as you know, I sent you in a note at 4 o'clock asking if you wanted to go home and come back tomorrow. You said yes. I apologize. It took us so long to get everybody together to do this. So I'm going to excuse you for today. When you come back tomorrow, you will start again after coming into the courtroom. So I do have to give you those 3 cautions, and the cautions also concern the alternate. So please do not discuss this case or any aspect of this case with anybody. Do not do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. You've all worked so hard for this last 8, 9, 10 weeks, however long it is. Let's just make sure that you continue to be as secure in how you've done things as you think. We really appreciate it. So we will see you tomorrow morning. Have a good night.
All right.
All rise, jury up.
No, my feet's not behind. I'm live. I am live. So it's not me that's behind. It's Channel 10 Boston that's behind. So it's not me. All right. Well, that's the end of that. So, okay. No verdict today. Very disappointing. All right. I'm going back to being lazy and stream sniping.
Thank you, Your Honor.
All right. We will see you tomorrow. Well, I know people may be a little bit surprised. Thank gosh it shouldn't take this long. It wouldn't take me this long. I get it.
Yep. No.
But it's not a bad thing. I wouldn't infer anything from it. They need to be thorough.
No, they don't.
And they need to take the time they need to take.
No, they really don't.
I don't think there's anything in this time frame so far that would alarm me. I had picked the over anyway, and you certainly know how I feel about the evidence in this case. But it's normal to take some time and go through stuff and make sure that they haven't missed
I also
anything.
like Andrew's background with the fish. I think it's a really cool background.
Michelle, concerning your legal career, what is your proudest moment? Again, thanks for helping keep my sanity over the kids' summer breaks. That's a tough one. That's a tough one. I had a win pretty recently, a case that I won on appeal that it meant a lot to me. It was a very hard case. It was a murder charge. A woman was charged with murdering her boyfriend. They had a very high conflict relationship. Part of their like
I
final
think
dispute,
they're piranhas.
I guess you would
I'm
call
pretty
it.
sure they're
You
fish. I
can,
think
you
they're
can see
piranhas.
on camera at their house. She comes out of the garage. She's holding the knife. The man is screaming at her, like getting up in her face, you know, being very physical. He's getting into the car to leave. She's trying to keep him from leaving. It's her car. You know, she needs the car. She's trying to keep him from leaving. She reaches into the car, and you can't see what happens. You just see like her whole torso kind of going inside the car. He ends up with a knife in his chest, and he dies from it. She you know, sees what happened, doesn't have much of a memory of it, and gets in to drive him. She's driving him to the hospital. Made the unfortunate decision to speak with police, which you should never do, because she didn't remember clearly what had happened. So then police go and find this video, watch this video. They're like, oh, some of these details are inconsistent with what she told us. Like, she didn't remember coming out of the house with the knife. Her recollection is just, I had the knife, and then he had the knife, and then I had the knife. She describes being assaulted in the home by the boyfriend, you know, pretty seriously assaulted, and he threatened her with the knife. And then she ends up getting the knife as he's leaving to go take her car and leave. And there is evidence in the house that supports that. You know, just chaos, things thrown around, you know, blood smears, and she's got a black eye when she's arrested. She's got marks around her throat. So it seemed pretty clear that, you know, she was not making that up. There had been a serious domestic altercation in the house. It was a tough case in part because I knew the participants. This was back in the county where I used to practice, and I had to argue ineffective assistance of counsel. I don't like doing that. It's not my favorite thing to do. Because, you know, I've been in that position. I know how hard it is to be making decisions on the fly and stuff like that. But ultimately, it's everybody who is the defense's lawyer. It's everybody's responsibility to put her interests first. So I had argued ineffective assistance of counsel because the attorney had just flat out misunderstood the requirements of self-defense. She had gotten a self-defense instruction for murder and was acquitted of murder. She had gotten a self-defense instruction for involuntary homicide, but the jury never got to involuntary homicide. They convicted her of voluntary manslaughter, on which the defense attorney, for whatever reason, believed she was not entitled to a self-defense instruction. So they weren't allowed to argue for manslaughter that she had acted in self-defense when she, you know, she recovers the knife, takes it out to the car, and then there's just this whatever struggle. So I did win that one, won that on appeal, got ineffective assistance, and, you know, conviction got reversed. It got remanded. She gets a new trial. I was really proud of that one in part just because, you know, it's an argument that you don't want to make, but you have to because it's the right thing to do. And just because under the facts of that case, she was very mistreated throughout the whole process. I watched her being re-victimized throughout this whole process. Just the things that were said about her, the way the prosecutor had chosen to try the case, the accusations she had made against her. This is a woman who had very severe childhood trauma of her own, which was not a secret. It was very well known, understood. Because she was known in the community from, you know, the time she was a child and had her own just family chaos to deal with. So just a girl who was kind of falling into that same pattern that we see, you know, over and over again, the cycle of abuse. She had tried to educate herself, tried to learn about it, but still just got sucked right into that. So it was just a situation where I felt like it was, you know, there's no justice. There's no right outcome with something like that, because no matter what, a young man is dead, and that's not a good thing. That's never a good thing. But, you know, her life didn't need to be spent on that as well. Her children, you know, deserve to have their mother. This wasn't a situation where, oh, she's, you know, a cold-blooded person who takes advantage of you know, an opportunity or something to perpetrate this murder that like she secretly wanted to or something. It was just nothing like that. So it was a situation where I felt very strongly that justice was done and that I played an important role in that. So I would say it's probably that one.
All right. I'm going to, I think, pan out here at this point. I've been on all day. So I will edit this at some point. I don't have the energy to edit this right now. I don't have the energy to edit this right now. So I might just edit it later and post it tomorrow. Maybe I'll post it tomorrow at noon or something. I don't know. But yeah, I need to edit it down. It might be about an hour long anyway by the time I throw my commentary and stuff. So it might be no shorter than the actual closing, but I'm going to try to get rid of some of the stuff that, you know, it's whatever and go from there. Yeah, I'm tired. I'm beat. So yeah, check out my merch shop. You guys see the link at the pinned comment there. And what are we on the count right now? Ooh, we're really close. Really close. 140,905. So I don't know if there are 95 of you in chat who haven't subscribed. But if there are 95 of you in chat who haven't subscribed, now would be a really good time to hit that subscribe button. I'm just saying, you know, I mean, now would be convenient, and we could cross another 1,000 threshold by the end of the stream. So if you haven't hit the subscribe button, now would be a good time. Yeah. So, well, there's one. Yeah, if not tonight, we'll beat him. We'll have it tomorrow. But I'm glad you did the Switch Prime thing. That's very kind of you. 909, 910. I can only have one. 911, 912, 913. Well, tomorrow then, I guess. Tomorrow then. How long am I expecting them to deliberate? Not that long. After lunch would be the most logical time. They usually come back like just after break. So if you had to project a time, then you'd say 2 p.m. I think this is when they come back from lunch. So something like that. 9:15. Yeah. I will I'll celebrate my 141 tomorrow. But we're close. So hey, that's nice. And then we'll be on to the US Supreme Court at some point. So that'll be cool. That's probably what we'll do tomorrow. We'll probably edit, you know what I might do? I might do a stream tomorrow and like do verdict watch. Yeah, that's actually not a bad idea. So maybe I'll get up early in the morning and maybe I'll like start verdict watch and I'll edit the closing argument live on stream with you because I need you to keep me company while I'm doing it. And so that will not be a members only. That would be open to everybody. But we'll do it that way. And then we could maybe, depending on my energy levels and how long that takes, maybe we could do some Supreme Court stuff. And that'd be cool. And we could start to record and start to think about trying to get that edit out. That'd be cool. So we'll see. All right. Can I shout out Ashley at Bearded Buffalo Resort? Hello, Ashley at Bearded Buffalo Resort. I hope you're having a great day. And I hope that your day will be awesome. And please tell me more about the Bearded Buffalo. Can Bearded Buffalo be my friend? That'd be cool. So yeah, I will come on and we'll probably do Verdict Watch tomorrow. And we'll edit during Verdict Watch and that'll be fine. And then I'll just post like an edited video and we can watch it together, I guess. So that'll be fun. All right, guys, I'm going to sign off for now. I've been Uncivil Law. Until later, my friends. I hope all's well. Cheers for now, my friends, and goodbye.